Roman 7 preface. Most Americans are so accustomed to the Social Security number that they simply assume that having a Social Security number is a legal requirement to being American. At every turn, Americans are challenged to provide a Social Security number. You need a Social Security number for school, insurance, employment, banking, credit, and a driver's license. Even your dentist or doctor is likely to ask you for a Social Security number. Yet millions of natural-born Americans do not have Social Security numbers. They do not have a Social Security number because they don't want one and, to the surprise of most Americans, they are not required to have one. According to the Social Security Administration, there is no law requiring a person to have a Social Security number to live and work in the United States, nor is there any law requiring a person to have a Social Security number simply for the purpose of having one. The simple fact is that there is no law requiring anybody to obtain, have, or use a Social Security number. There are, however, many laws defining the use and application of Social Security numbers when a person chooses to use one. There are also several laws that protect people against discrimination when they choose not to use a Social Security number. The incorrect assumption by most Americans that there must be a law requiring them to have a Social Security number has led to many misunderstandings and, in many cases, lost opportunities. Many bankers have unnecessarily turned away good potential customers, and many employers have turned away excellent workers because their policy improperly discriminates against unenumerated individuals. Too often, this discrimination has led to unnecessary litigation and additional losses to the businesses. This manual provides information and guidelines for businesses, bankers, employers, and individuals for legally and properly dealing with people who choose not to use a Social Security number. This manual also discusses the legal requirements associated with using Social Security numbers and many of the forms that request a number. Policy Manual Roman 8. What you will learn while reading this manual: you will learn the answers to the following issues. How has tens of thousands of Americans quit Social Security and stopped paying Social Security taxes? Does the law require an employee to have a Social Security number? Does the law require an employer to sign an IRS Form W-4, Employee Withholding Allowance Certificate? Does the law require an American to get a Social Security number? Does the law require an American to obtain a Social Security number for their child? Is it possible to vote, open a bank account, drive a car, buy and sell property, act without a Social Security number? What does that mean? Are you really required to have a telephone number? Based upon the following review of several federal laws, we might conclude that most Americans are required, by law, to have a telephone number. 29 U.S.C. Section 213 requires that employers and employees shall provide the name, telephone number, and address of the employer and the name, telephone number, and address of the employee. As a passenger on any commercial airline, Federal Law 49 U.S.C. 44909 requires that the passenger manifest shall include the name and telephone number of a contact for each passenger. U.S.C. Section 1603 requires that individual who register as lobbyists shall contain the name, address, business telephone number. 42 U.S.C. Section 666 states that each party to any paternity or child support proceeding is required to include Social Security number, residential and mailing addresses, telephone number, driver's license number, and name, address, and telephone number of employer. 11 U.S.C. Rules Form 1 requires a debtor not represented by an attorney to provide a telephone number. 26 U.S.C. Rule 24 states that any person who wishes to represent himself without counsel shall state, in the initial pleading, such person's name, address, and telephone number. U.S.C. Section 104A states that the owner of a copyright who files a notice of intent to enforce a restored copyright shall include an address and telephone number at which the owner may be contacted. 28 U.S.C. Rule 26 states that each witness at a pretrial disclosure shall provide to other parties the name, address, and telephone number of each witness. 26 U.S.C. Rule 241 states that the petitioner for an action for readjustment of partnership shall contain the signature, mailing address, and telephone number of each petitioner. 26 U.S.C. Rule 34 states that the petitioner for an action for deficiency or liability actions, the petition in a deficiency or liability action shall contain the signature, mailing address, and telephone number of each petitioner. 26 U.S.C. Rule 291 states that the petitioner for an action for redetermination of employment status shall contain the signature, mailing address, and telephone number of each petitioner. 26 U.S.C. Rule 281 states that the petitioner for an action for review of failure to abate interest shall contain the telephone number of each petitioner. 26 U.S.C. Rule 271 states that the petitioner for an action for administrative shall contain the signature, mailing address, and telephone number of each or each petitioner's counsel. Therefore, based upon that review, and the understanding that the word shall is generally the same thing as an imperative or mandatory requirement having somewhat the same meaning as the word must, then phrases such as shall provide, shall include, shall contain, and shall state makes it pretty obvious that the individual affected by these laws must have a telephone number. 29 U.S.C. Section 213 requires all employers and employees to have a telephone number. 49 U.S.C. Section 44909 requires passengers on a commercial flight to have friends who have telephone numbers. 42 U.S.C. Section 666 requires everybody to have a telephone number. Okay, I admit this might be stretching things here. But no, because this is the same law that the states are claiming requires them to demand your social security number when getting a driver's license. 26 U.S.C. Section 24 requires that anyone representing themselves in tax court must have a telephone number. 17 U.S.C. Section 104A prohibits you from restoring your copyright without a telephone number. 28 U.S.C. Rule 26 prohibits you from being a witness if you don't have a telephone number. 26 U.S.C. Rule 241 requires individuals to have a telephone number before they can enter into a partnership. So, certainly based upon this understanding of the law, we should logically conclude that individuals who wish to become employers, employees, friends of airline passengers, or everybody because men and women could possibly become involved in a paternity suit is required to obtain, have and use their telephone number. Either that, or we need to reevaluate the legal meaning of the word shall. A brief glossary weasel word. A word that has the appearance and feel of meaning one thing while actually meaning something entirely different. The meaning of the word shall. Black's Law Dictionary defines the meaning of the word shall as 26 U.S.C. Rule 221 states that petitioner for a disclosure action shall include the telephone number of the petitioner or the petitioner's counsel. 26 U.S.C. Section 6104 states that certain exempt organizations shall state the address and the telephone number of the private foundation's principal office and the name of its principal manager. Shall. As used in statutes, contracts, or the like, this word is generally imperative or mandatory. The word in ordinary usage means must and is inconsistent with a concept of discretion, but it may be construed as merely permissive or directory as equivalent to may. What does that mean? Roman 11. The word shall is a key word in many statutes, leading many readers to assume that it has a similar meaning to the word must. However, based upon the above telephone logic, most of you are probably thinking that the word shall might actually be similar to the word may or the word should. When we examine the following 5 court rulings, we begin to understand that it really does mean may in most cases. It is the opinion of the courts that if a statute specifies that a certain act shall be done, and there is a question about whether or not it would be constitutional for the act to be mandatory, then the word shall takes on the permissive meaning rather than the mandatory one. The First Amendment of the Constitution of the United States protects the freedom of speech and of the press. You should understand that the freedom to speak also involves the freedom not to speak. If you do not have the right not to speak, i.e., if the government could compel you to speak, then you have no freedom of speech. Since this might extend to printed and written materials, you have a First Amendment right not to fill out government forms and not to give the government information. The Fourth Amendment of the Constitution of the United States protects your privacy. You have a Fourth Amendment protected right to keep your personal financial affairs private and not to voluntarily give that information to the government. The Fourth Amendment provides that if the government wants to examine your books and records, a court order must be obtained. The word shall in a statute may be construed to mean may, particularly on the order to avoid constitutional doubt. Fort Howard Paper Co. v. Fox River Heights Sanitary District, 26 NW 2nd 661. If necessary to avoid unconstitutionality of a statute, shall will be deemed equivalent to may. Gao v. Consolidated Coppermans Corporation 165 at 136. Shall in a statute may be construed to mean may to avoid constitutional doubt. George Williams College v. Village of Williams Bay, 7 NW 2nd 891. As against the government, the word shall when used in statutes is to be construed as may, unless a contrary intention is manifest. Cairo and Fulton R.R. Co. v. Hecht, 95 U.S. 168. The word shall in a statute may be construed as may where the connection in which it is used or the relation to which it is put with other parts of the same statute indicates that the legislature intended that it should receive such construction. Ballou v. Kemp, 92 F. 2nd 556. Amendment I. Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble and to petition the government for redress of grievances. Amendment Roman for the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause supported by oath or affirmation and particularly describing the place to be searched, and the persons or things to be seized. The Fifth Amendment of the Constitution of the United States protects you as well, stating, "The Fifth Amendment seems to apply only to criminal matters, but the Supreme Court ruled in McCarthy v. Arnstein, 266 U.S. 34, that the Fifth Amendment applies alike to criminal and civil proceedings. Similar rulings have stated." Thus, based on the constitutional issues presented above, the word shall must have the permissive construction may, because the mandatory construction would violate the Constitution, the supreme law of the land. The effect of the government's actions has been noted by the Supreme Court. The meaning of the word include. Another key word in many statutes is the word include. This is another word with a double meaning. The general population uses this word to infer that there is an additional element to our subject matter. For example, the statement "the flight of the chicken includes, among other things, a rather haphazard landing" leads you to believe that besides an eventful airtime and an interesting landing, there is more to the total process of a chicken flying. Our thought process does not exclude other happenings and seeks no closure to the subject. However, the legal definition of the word includes describes the word as one of limitation. Black's Law Dictionary defines the meaning of the word include as: the term include, includes, or including appears in many places within the code. It is sometimes preceded or followed within a few words by another tricky double-talk word. Shall. Amendment v. No person shall be held to answer for a capital, or otherwise infamous crime, unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces, or in the militia, when in actual service in time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property, without due process of law, nor shall private property be taken for public use, without just compensation. There can be no question that one who files a return under oath is a witness within the meaning of the amendment. Sullivan v. United States 15 F. 2nd 809, and the information revealed in the preparation and filing of an income tax return is, for Fifth Amendment analysis, the testimony of a witness as that term is used herein. Garner v. United States 424 US. 648. Because of what appears to be a lawful command on the surface, many citizens, because of their respect for what only appears to be law, are cunningly coerced into waiving their rights due to ignorance. U.S. v. Minker 350 U.S. 179 at 187. Include. To confine within, hold as in an enclosure, take in, attain, shut up, contain, enclose, comprise, comprehend, embrace, involve. The meaning of the word fail. Black's Law Dictionary defines the meaning of the word fail as: that is, you failed to do something because you were lazy and forgot, or because you simply refuse. You do not fail to do something because it is beyond your control. For example, you cannot fail to furnish a telephone number if you don't have a telephone. So, what does it really mean? If the law says that you shall furnish your telephone number and you have a telephone number, then you could furnish it. However, there is no expectation for you to furnish your telephone number if you do not have a telephone and you have not failed to furnish that which you do now have. If the law says that you shall include your name and address, you would not interpret that to also include your telephone number. In the legal sense, the list following the word include is the entire list of everything included. Nothing else can be interpreted to be added to the list. The legal meaning of words are often given specific meaning within the confines of a title or section within the law. For example, it is also important to read these definitions carefully, because their usage is often more restricted than it first appears. A good example of this is found for the definition for include that is provided in the United States tax law in Title 26. We see that the word include has the intended usage that we expect from our common language. However, notice that this usage is restricted to when used in a definition. That is to say that when the word include is used only within the contents of a definition for a word fault, negligence, or refusal. 10 USC 101 Title 10 Armed Forces Subtitle General Military Law Part I Organization and General Military Powers Chapter 1 Definitions Sec. 101. Definitions E. Rules of Construction. In this title, 1 shall is used in an imperative sense. 2 may is used in a permissive sense. 3 no person may **** means that no person is required, authorized, or permitted to do the act prescribed. 4 includes means includes, but is not limited to. And 26 USC Section 7701. Definition C. Includes and including the terms includes and including when used in a definition contained in this title shall not be deemed to exclude other things otherwise within the meaning of the term defined or term, then it has this special meaning beyond that content. That is, when the word include is used in anything else, it has the legal meaning that was defined above. Pay particular attention to these words as you read the law. Now you should be able to go back and reread the telephone list at the beginning of this section and understand clearly what is being said. As a practice, you should do that before proceeding. Who's bound by the law? Many laws restrict or require something of citizens, but the overwhelming majority of laws and regulations are written for the various government agencies. Citizens never need permission from the law to do a thing. Government agencies, however, must have explicit permission for each thing that they do. A state and federal agency cannot do anything that is not explicitly authorized by law. To do so is illegal. A government agency violates the law when it does something that the people have not given it permission to do. In America, people have rights, the government has permission. 1. The history of the Social Security number. The Federal Social Security Act Pub. Law 74, 71, August 14, 1935, 49 Stat. 620. As amended is codified at 42 U.S.C. Section 301, 399. The first mention of the Social Security number in a law or regulation is a Bureau of Internal Revenue regulation dated November 5, 1936, where an identifying number, called an account number, was assigned to employees covered under the Act. TD 4704 1 Fed. Reg. 1741 Nov. 7, 1936, 26 CFR, Part 401 First ed. 1939. This regulation was issued pursuant to Section 8.7b of the Social Security Act of 1935 and was not a mandatory requirement, but simply a directory. In the beginning, there was little use of the Social Security number other than being required as an identifier for people receiving benefits under the unemployment compensation programs contained in the Act and administered by the states. Few Americans had been issued numbers by the 1940 because they were not receiving these benefits, and few organizations felt the need for a numeric identifier. Although today, most people are under the impression that a Social Security number is required for more than just Social Security purposes, this is not the case and never has been. This impression came, in part, from the fact that in 1943, the Civil Service Commission decided that there should be a numerical identification system for all federal employees and proposed to the Bureau of the Budget that the use of the Social Security number be authorized for this purpose. This led to the issuance of Executive Order 9397, which provides, in part, as follows. The order directed the Social Security Board, the predecessor agency of the Social Security Administration, to provide for the assignment of an account number to any person required by any federal agency to have one, and to furnish the number, or the name and identifying data, pertaining to any person or account number upon request of any federal agency using the Social Security number for a numerical identification system of accounts under the order. Whereas certain federal agencies from time to time require in the administration of their activities a system of numerical identification of accounts of individual persons, and whereas it is desirable in the interest of economy and orderly administration that the federal government move towards the use of a single, unduplicated numerical identification system of accounts and avoid the unnecessary establishment of additional systems. Now, therefore, it is hereby ordered as follows. 1. Hereafter any federal department, establishment, or agency shall, whenever the head thereof finds it advisable to establish a new system of permanent account numbers pertaining to individual persons, utilize exclusively the Social Security Act account numbers. The issuance of Executive Order 9397 in 1943 theoretically provided the basis for this change in conception of the role of the Social Security number. This interpretation was taken from the wording of the order, which speaks of the efficiency to be gained from a single system of accounts. To interpret the order as applying to all kinds of federal agency record systems was certainly beyond the meaning of its language. In 1946, the Social Security Administration, complying with the provisions of the Administrative Procedures Act of 1946 Pub. Law 79-4 60 Stat. 237, required among other things, uniformity, impartiality, and fairness in the procedures employed by federal administrative agencies, issued and published in the Federal Register its regulations on the issuance and use of Social Security numbers. 20 CFR, Section 422.1 Roman II, published at 11 FR. 177A 568, September 11, 1946, provides. In 1961, the Internal Revenue Service began using the Social Security number for taxpayer identification by an amendment to the Internal Revenue Code Pub. Law 87-397, 75 Stat. 1828, Internal Revenue Code of 1994, Sec. 6109, that authorized the Secretary of the Treasury to request that each person making a return, statement, or other document under the Internal Revenue Code to include such identifying number as may be prescribed for securing proper identification of such person. In a decision dated April 16, 1964, the Commissioner of Social Security approved the issuance of Social Security numbers to pupils in the 9th grade and above, if a school requests such issuance and indicates willingness to cooperate in the effort. The Social Security Administration claims manual explains that this decision was made to accommodate requests from school systems desiring to use the Social Security number for both automatic data processing and control purposes, so that the progress of pupils could be traced throughout their school lives across district, county, and state lines. The school enumeration program, however, is entirely voluntary. In June 1965, the Commissioner of Social Security authorized the issuance of a Social Security number to every recipient of state old age assistance benefits who did not already have one, in order to establish a more efficient process for exchange of information between these agencies and the Social Security Administration. The Congress, in Section 137 of the Social Security Amendments of 1972 Pub. Law 92,603, 86 Stat. 1329, 42 U.S.C. Section 405C 2B a Roman II, requires the Secretary of the Department of Health, Education, and Welfare, the predecessor agency of the Department of Social and Human Services, to take affirmative measures to issue Social Security numbers to any individual who is an applicant for or recipient of benefits under any program financed in whole or in part from federal funds, including any child on whose behalf such benefits are. Roman II. Any person who wishes to file an application for an account number may do so by filing Form SS-5. The history of the Social Security number 3 claimed by another person. The quoted language of this requirement appears to call for the issuance of a Social Security number to virtually everyone in America who did not already have one, but the legislative history clearly indicates that such universal enumeration was not intended. Under the 1972 amendments, all members of Aid for Families with Dependent Children Act households, including children, are required to furnish their Social Security number in order to qualify for benefits. See 42 U.S.C. Section 16 25, 1976. This statutory scheme has since been amended, although the Social Security number requirement has been retained in virtually identical form. See Deficit Reduction Act of 1984 Pub. Law 98-69, Section 351 98 Stat. 1147. If they do not have a social security number, they must apply for them. See 45 CFR. Section 232.10 F 1973. This regulatory requirement was upheld in Chamber v. Klein 409 F. Sup. 569 DC NJ. 1976, which ruled that requiring social security numbers as one condition for receiving aid aft did not violate any constitutionally protected right to privacy. In April 1974, it was decided that participating states could enumerate Medicaid recipients in addition to AFT beneficiaries. Under the Tax Reform Act of 1976 Pub. Law 94-455, 90 Sat. 1520, states are authorized to require Social Security numbers as identifiers for state programs, including general public assistance. See 42 U.S.C. Section 405 C2C. In addition, since 1980, Social Security numbers are an eligibility requirement for many food stamp household members. See 7 U.S.C. Section 2025E. From this review of the federal actions, which is far short of an exhaustive list, it is clear that the federal government itself has been in the forefront of expanding the use of the Social Security number. But it is also clear that the enumeration of individuals under the Social Security Act was intended to be limited to those receiving federal entitlements. The requirement for and the use of the Social Security number in connection with these federal and state-administered welfare programs enhances the program's efficiency and helps to reduce the tremendous problems of mispayment of benefits by the agencies involved with the administration of these programs. See Callahan v. Woods, 736 F.2D 1269, 1274 9th Sir. 1984. With increasing demands being placed on individuals to furnish a Social Security number in circumstances when use of the number is not required by federal law or regulation, the Congress in 1974 passed the Privacy Act of 1974 Pub. Law 93-79 A8 Stat. 1896, as amended. Section 7 of Pub. Law 93-79 provides. The relevance of this act is simply that it highlights the importance of privacy interests associated with Social Security information. Cf. Wallman v. United States, 501F. Sup. 310 DC 1980, remanded 1675 F.2D 11341 DC. Sir. 1982, vacated on other grounds, 542F. Sup. 84 DC 182 Section 7 of the Privacy Act was intended, the District Court found, to block indiscriminate governmental use of Social Security information as though one it shall be unlawful for any federal, state, or local governmental agency to deny to any individual any right, benefit, or privilege provided by law because of such individual's refusal to disclose his Social Security account number. Universal Identifier. See United States v. $200,000 in U.S. currency 590F. Sup 866 SD. Flaw. 1984. The Privacy Act makes it unlawful for any person to require an individual to disclose or furnish a Social Security number for any purpose, unless the disclosure or furnishing the number was specifically required under federal law. In enacting Section 7, Congress sought to curtail the expanding use of Social Security numbers by federal and local agencies and, by so doing, to eliminate the threat to individual privacy and confidentiality of information posed by common numerical identifiers. CS. Rep. No. 1183, 93rd Con. 2nd. Sess reprinted in U.S. Code Con. And Admin. News pp. 6016, 6044. Underlying this legislative effort was the recognition that widespread use of a standard identification number in collecting information could lead to the establishment of a national data bank or similar informational system, which could store data gathered about individuals from many sources and facilitate government surveillance of its citizens. ID at 694, 45, 695-7. It was anticipated that as the use of the Social Security number proliferated, the incentive to consolidate records and to broaden access to them by other agencies of government would, in all likelihood, correspondingly increase. ID at 6945. Thus, Congress saw a need for federal legislation to restore to the individual the option to refuse to disclose his Social Security number without repercussions, except in specifically delineated circumstances outlined in Section 7(2). Since its passage in 1974, the federal courts have ruled the Privacy Act applies equally to the private sector. The requests for Social Security numbers must conform to the disclosure requirements of the Privacy Act. Yeager v. Hackensack Water Co. 615 F. Sup. 1087 DCNJ. 1985. Since the passage of the Privacy Act, a state cannot use the lack of a Social Security number in any adverse way against anyone, unless required under federal law. A state cannot make something which is voluntary under federal law mandatory. The plain language of the Federal Social Security Act, its legislative history, regulations, and the relevant decisional precedents makes it clear that there is simply not a requirement that an individual must obtain and disclose a Social Security number, unless they receive federal welfare benefits and the disclosure of the number is required under applicable federal law. There is no law requiring a person to obtain, have, or use a Social Security number to live or work in the United States. 7. Employment issues. Since federal law does not require any individual to apply for and accept any federal benefits, let's now examine whether one federal law requires every employee to have a Social Security number in order to work, and 2. A Social Security number is required in order for an employer to meet all tax filing and reporting requirements under state and federal law. The two primary issues that lead employers to believe that each of their employees must have a valid Social Security number are the INS Form I-9 and the IRS Form W-4. Employment eligibility verification. The passage of the Immigration Reform and Control Act of 1986 (IRCA) sought to prevent illegal immigrants, principally from Mexico and other Hispanic countries, from finding work in the United States. This was done by imposing civil and criminal penalties against employers who knowingly hired such workers. As a result, there has been a movement toward requiring every American to have a national identification card or a work permit issued by a federal bureaucracy. However, it is a well-settled principle of American Constitution law that every member of a community has a right to enjoy a free labor market, to have a free flow of labor for the purpose of carrying on the business in which he has chosen to embark. This right is not merely an abstract one. It is one recognized as the basis of a cause of action where there is an unlawful interference with it. Specifically, laborers have a right to a free and open market in which to dispose of their labor, or a right to a free access to the labor market for the purpose of maintaining or increasing the incorporeal value of their capacity to labor. A laborer has the same right to sell his labor as any other property owner. Labor is deemed to be property, especially within the meaning of constitutional guarantees. Thus, the right to acquire property includes the right to acquire property by labor. Since the right to labor is protected by the Constitution and numerous guarantees of state constitutions, one cannot be deprived of such right by arbitrary mandate of the state legislatures and/or by the federal government. In Patton v. Bellingham, 179 Wash. 566, 38 p.2d3 64 1937, the Washington Supreme Court reaffirmed the principle of law that labor is a right of property by declaring, "The right to labor or earn one's livelihood in any legitimate field of industry or business is a right of property, and any unlawful or unreasonable interference with or abridgment of such right is an invasion thereof, and a restriction of the liberty of the citizen is guaranteed by the Constitution." EDV. City and County of San Francisco, 235 Fed. 757, 759. Any national legislation establishing a federal work permit or national identify card, utilizing a Social Security number as a condition for obtaining employment in the United States, seeks only to deprive Americans of a fundamental freedom, the right to earn a living. Since the right to labor and to its protection from unlawful interference is a constitutional, as well as a common law right, and since man has a natural right to the fruits of his own industry regardless of governmental demands, any legislation passed by Congress requiring every employer to verify an employee's Social Security number before commencing work would not be intended for controlling immigration, but passed solely for the purpose of destroying rights and the principles of freedom and justice upon which the Constitution rests, which is probably why no such law exists. Internal Revenue Service requirement. Today it is common for an employer to require a social security number from an employee under the mistaken belief that unless the employee had a social security number, the employer would be in violation of internal revenue regulations and subject to numerous penalties. The employee is notified that unless they obtain a social security number, they will be terminated. However, the Internal Revenue Code and regulations do not contain an absolute requirement that an employer must provide an employee's social security number to the Internal Revenue Service. 26 U.S.C. Section 6109(3) provides. The IRS regulation interpreting 26 CFR Section 6109 provides. The applicable federal statute and regulation place a duty on the employer to request a taxpayer identifying number from the employee, if any return, statement, or other document must be furnished to the Internal Revenue Service and the employer has been unable to obtain an identifying number from the employee after requesting the number, then the employer need only to include on the transmittal document forwarding such returns, statements, or other documents an affidavit stating that the request for the number was made. Until December 1989, 26 U.S.C. Section 6 and 1676 1989 set forth the penalties for failing to supply the Internal Revenue Service with the identifying number. This section states that a $50.00 penalty will be imposed for failure of an employer to provide an identifying number on any person required under the authority of this title to make a return, statement, or other document with respect to another person, shall request from such other person, and shall include in any return statement or document such identifying number as may be prescribed for securing proper identification of such other person. 26 USC Section 6109(3). If he does not know the taxpayer identifying number of the other person, he shall request such number of the other person. A request should state that the identifying number is required to be furnished under the authority of law. When the person filing the return, statement, or other document does not know the number of the other person, and has complied with the request provision of this paragraph, he shall sign an affidavit on the transmittal document forwarding such returns, statement, or other documents to the Internal Revenue Service so stating. 26 IFR Section 301.6109-1C. Employment Issues 9 Document filed with the Internal Revenue Service unless it is shown that the failure is due to reasonable cause and not willful neglect. The regulation interpreting the statute provides. Under Section 301.6109-1C, a payer is required to request the identifying number of the payee. If after such a request has been made, the payee does not furnish the payer with his identifying number, the penalty will not be assessed against the payer. The Omnibus Budget Restoration Act of 1983 Pub. Law 1-1-239, Title Roman 7, Section 711(11)(b)(1), repealed Section 676 of the Internal Revenue Code effective for statements or documents filed after December 31, 1989. Since December 31, 1989, Code Section 6723 has governed the failure to comply with information reporting requirements. Section 6723 provides that a penalty of $50.00 shall be assessed for each failure to comply with a reporting requirement. However, 26 USC Section 6724 provides for a waiver of any penalties assessed under the Code upon a showing of reasonable cause. Section 6724 provides. Therefore, the Code and regulations mandate a payer only to request the identifying number of the employee or payee. If after such a request has been made, the payee does not furnish the payer with his identifying number, the penalty will not be assessed against the payer upon the filing of an affidavit with the Internal Revenue Service stating that a request for the payee's identifying number was made. How to hire an unenumerated employee. Most employers believe that they are required by law to obtain a Social Security number from each employee. Additionally, the advice from the employer's attorney or accountant usually reinforces this opinion. Often the advice further suggests they should terminate the employee in question. However, closer examination of the law and regulation is prudent. Each American, enumerated or not, has broad, legally protected rights. Violating a person's rights can lead employers into serious legal and financial problems, and in some cases, even jail. Be certain that your decision to terminate an unenumerated employee is based on competent legal advice from an attorney who can represent you in court. Getting legal advice from an accountant is unwise. Additionally, employers also need to recognize that the Internal Revenue Service will not appear in court on their behalf, even when they advise terminating an unenumerated employee. According to the Constitution of the United States, only Congress can make law. Laws become codified into the United States Code books after they pass through and are finally signed by our President. Often, Congress delegates authority to various departments to create regulations for implementing these laws. These regulations are codified into the United States Code of Federal Regulations. No penalty shall be imposed under this part with respect to any failure if it is shown that such failure is due to reasonable cause and not willful neglect. 26 USC Section 6724. Complying with Internal Revenue Service requirements. The law, 26 U.S.C. Section 6109D stipulates that when an individual's identifying number is specified or used by the Internal Revenue Service (IRS), the identifying number will be the Social Security number that was assigned to that individual by the Social Security Administration. Specifically, the law says, according to the Internal Revenue Service, employers are required to ask an employee for a Social Security number and record the number if it is available or make a notation unknown if the number is not available. There is no legal requirement that an employee have a Social Security number, nor is there a requirement that the employer obtain a Social Security number from an employee. D. Use of Social Security account number. The Social Security account number issued to an individual for purposes of Section 205(c)(2) of the Social Security Act shall, except as shall otherwise be specified under regulations of the Secretary, be used as the identifying number for such individual for purposes of this title. 26 USC Section 6109D. Figure 1. Example of IRS. S. Intimidating and fraudulent response. The regulation, 26 CFR Section 31.6011b, specifically, Section 6011b(2) discusses employee account numbers and delineates the process employees and employers should go through to collect the proper number. This section also discusses how an employee who does not have or know the number may obtain a Social Security number, should they wish to do so. The section also discusses the employer's obligation to assist an employee in applying for a Social Security number. But the section does not require an employee who has not been issued a Social Security number, because they do not want a Social Security number 1, to obtain one. This section is sometimes referred to when a legal department is trying to say that employees are required by law to have a Social Security number. Specifically, they will quote 26 CFR Section 31.6011b(2)(b) Roman 4, which reads, the wording of this portion of code can be a bit confusing. Certainly phrases such as shall furnish to the employer do appear to mandate the requirement. However, this portion of code belongs to a section regarding the duties of an employee with respect to his account number. That is, it is written for an employee who either doesn't remember his account number, or is not sure if an account number has been assigned and wants to obtain a number if one has not been assigned. This section of code does not require an employee who does not wish to obtain a Social Security number to obtain one. Additionally, note the use of the permissive term shall see page X. However, employers are not relieved of the requirement of asking an employee for a Social Security number, simply because an employee does not have or wish to obtain a Social Security number. Specifically, 26 CFR Section 6011b(2)(c) requires an employer to do one or more of the following 6 things when attempting to obtain an employee's Social Security number. 1. Note the employer is expected to assist an employee who wishes to obtain a Social Security number. However, some employees may not want a Social Security number. This regulation does not require an employer to assist those employees who do not wish to obtain a Social Security number. 26 CFR Section 31.6011b(2)(b) Roman 4. B. Duties of employee with respect to his account number. Roman 4. Employee who is unable to furnish number or receipt. If an employee is unable to comply with the requirement of paragraph B1I, Roman 2, or Roman 3 of this section, the employee shall furnish to the employer a statement in writing, signed by the employee, setting forth the date of the statement, the employee's full name, present address, date and place of birth, father's full name, mother's full name before marriage, and the employee's sex, including a statement as to whether the employee has previously filed an application on Form SS-5 and, if so, the date and place of such filing. The information required by this subdivision shall be furnished on Form SS5, if a copy of Form SS5 is available. The furnishing of such a Form SS5 or other statement by the employee to the employer does not relieve the employee of his obligation to make an application on Form SS5 and file it with the District Office of the Social Security Administration as required by paragraph of this section. The foregoing provisions of this subdivision are not applicable to an employee engaged exclusively in the performance of domestic service in a private home of his employer, not on a farm operated for profit, or in the performance of agricultural labor, if the services are performed for an employer other than an employer required to file returns of the taxes imposed by the Federal Insurance Contributions Act with the Office of the United States Internal Revenue Service in Puerto Rico. However, such employee shall advise the employer of his full name and present address. Table 1. The duties of employer. Condition: employer must 1. Employee shows account number. Employer shall enter the account number and name, exactly as shown on the card. 2. Employee does not show account number card. Employer shall comply with the following. I. Employee has not applied for account number. Employer shall inform the employee to get a card. 2. Employee has account number. Employer shall enter it in his records. 3. Employee has a receipt for application. Employer shall enter it in his records. 4. Employee furnishes Form SS5 or statement. Employer shall retain a copy of such information. V. Employee is a household or agricultural worker. Employer shall enter their name and address. 26 CFR Section 6011B2C6 provides that employers are not required to ask prospective employees for a Social Security number, but instead suggests that an employer should ask. The law protects the employer. Federal law requires employers to request a Social Security number from payees, employees, or contractors. There is no federal law actually requiring this disclosure as a prospective employees. While not mandatory, it is suggested that the employer advise any prospective employee who does not have an account of the requirements of paragraph A and B of this section. 26 CFR Section 6011B2C6. Condition of employment or contract, and there is no penalty for failing to obtain this disclosure. 26 CFR 301.6109-1C prescribes the procedures that an employer must follow. This regulation requires a payer to request disclosure of the identifying number. If disclosure is refused, a second request must be made, stating that disclosure is required by federal law, even though it is not required by federal law. If disclosure is refused a second time, the payer must attach an affidavit to any forms needing the Social Security number, stating that the requirements for requesting disclosure have been met. No federal or state law imposes any penalty for not obtaining disclosure of a Social Security number as a condition of employment. 26 U.S.C. Section 6723 provides that a penalty of $50.00 shall be assessed for each failure to comply with a reporting requirement. However, 26 USC Section 6724 provides for a waiver of any penalties assessed under the code upon a showing of reasonable cause. Section 6724 provides no penalty shall be imposed under this part with respect to any failure if it is shown that such failure is due to reasonable cause and not willful neglect. 26 USC Section 6724. Therefore, it is prudent that a business develop proof that it has complied with its requirement to ask an employee for, and was unable to obtain, a Social Security number. The following form or similar should be given to the employee for his signature. An employer should attach a copy of this completed form to your business tax return. Complying with Internal Revenue Service Form W-4. Most employment policies require that each employee complete an Internal Revenue Service Form W-4 before the employee can begin work. They incorrectly believe that 26 U.S.C. Section 3402 requires every employee to complete a Form W-4. Specifically, they refer to the notice on the lower back of the form, 26 USC Section 3004-2F2. 26 USC Section 3004-2. Income tax collected at source. A requirement of withholding 1 in general except as otherwise provided in this section. Every employer making payment of wages shall deduct and withhold upon such wages a tax determined in accordance with Form P-1 reasonable cause affidavit by payer for not obtaining payee's identifying number. Release from penalty. 26 U.S.C. Section 6724. Employer/payer's name and address, employer identification number, employer/payer statement. I, being an officer of, hereby state that I have asked for the identifying number of the employee/pay who has declined to provide an identifying number. I am filing this affidavit in accordance with 26 U.S.C. 6724, waiver of penalty 26 U.S.C. 6724 assessed under the Code upon a showing of reasonable cause, and Treasury Regulation 301.6109-1C. I certify that the information stated here is correct and that I asked the employee/pay for a taxpayer ID number, social security number, and that the employee/pay declined to provide such number. Employer/payer signature date, employee/pay information type or print, employee/pay first name and initial last name, social security number, write none if you do not have a SSN or declined if you do not wish to provide a SSN. Home address number and street or rural road, employee/pay statement. I have declined to provide an identifying number to my employer/payer. City or town, state, and ZIP code. I certify that the information stated here is correct and the employer/payer did ask me for a taxpayer ID number, social security number, and that I declined to provide such number. Employee/pay signature date 26 U.S.C. Section 6724, waiver of penalty 26 U.S.C. Section 6724 assessed under the Code upon a showing of reasonable cause, and Treasury Regulation 301.6109-1C. Treasury Regulation 301.6109-1C provides, when the person filing the return statement or other document does not know the SSN of the other person and has complied with the request provision of this paragraph, he shall sign an affidavit on the transmittal document forwarding such returns, statements, or other documents to the Internal Revenue Service, so stating. A payer is required to request the identifying number of the payee. If after such request has been made, the payee does not furnish the payer with an identifying number, the penalty $50.00 will not be assessed against the payer if it is shown that such failure is due to reasonable cause and not willful neglect. See also 26 U.S.C. Section 6724, waiver of penalty 26 U.S.C. Section 6724 assessed under the Code upon a showing of reasonable cause. Public Domain Privacy Form P-102 1999 Zip Construction, Inc. 1865 Tully Road, San Jose, Calif. 9534 5th Senor 631A23 John McGuire Zip Construction, Inc. Tom Brokaw 3672 Herman Road, Santa Cruz, Calif. Tom Brokaw Zip Construction, Inc. Declined John McGuire Tom Brokaw John McGuire 9/21/99 Tom Brokaw 9/21/99. This requirement is implemented in regulation at 26 CFR Section 31.3402 F21. Now that we have outlined the basic Internal Revenue Service requirement, let's look a little closer at what is being stated. Notice that 26 U.S.C. Section 3402(1) defines the application of this section by stating, except as otherwise provided in this section. Notice that 26 CFR Section 31.3402 F21 states that the employer is required to request a withholding exemption certificate from each employee, but if the employee fails to furnish such certificate. The phrase "if the employee fails to furnish such certificate" means that an employee may decline to provide the Form W-4. Note that it also states, such employee shall be considered as a single person claiming no withholding exemptions. We'll discuss this shortly. Understand that if the Form W-4, employee's withholding allowance certificate, were absolutely required from each employee, if it were, without exception, an absolute legally required mandate, then why is the employer required to ask for it and why must the employee furnish it? If it were clearly required, the law would simply direct the employer to do the withholding, without exceptions. This argument usually continues with the assertion that the regulation also provides that such employee shall be considered as a single person claiming no withholding exemptions. But the counter to this assertion is to clarify what is written here. The phrase "shall be considered as" does not authorize the actual withholding of money, it simply tells the employer how to think about this person. The authorization for withholding comes only with a properly completed and signed Form W-4 agreement. F. Withholding exemptions to exemption certificates on commencement of employment on or before the date of the commencement of employment with an employer. The employee shall furnish the employer with a signed withholding exemption certificate relating to the number of withholding exemptions which she claims, which shall in no event exceed the number to which she is entitled. 26 CFR Section 31.3402 F21 Withholding exemption certificates. On commencement of employment. On or before the date on which an individual commences employment with an employer, the individual shall furnish the employer with a signed withholding exemption certificate relating to his marital status and the number of withholding exemptions which he claims, which number shall in no event exceed the number to which he is entitled, or, if the statements described in Sec. 31.3402 N1 are true with respect to an individual, he may furnish his employer with a signed withholding exemption certificate which contains such statements. For form and contents of such certificates, see Sec. 31.3402 F51. The employer is required to request a withholding exemption certificate from each employee, but if the employee fails to furnish such certificate, such employee shall be considered as a single person claiming no withholding exemptions. The Form W-4 is a voluntary withholding agreement. The reason that an employee might fail to furnish such certificate is that 26 U.S.C. Section 3402(1), which defines the application of this entire section, states, except as otherwise provided in this section. While reading further on in the section, we find that otherwise provided is explained in 26 CFR Section 31.3402 P1, where it explains that the Form W-4 is a voluntary withholding agreement and its completion is not required by law. 26 CFR Section 31.3402 P1 Voluntary withholding agreements. In general, an employee and his employer may enter into an agreement under Section 3402B to provide for the withholding of income tax upon payments of amounts described in paragraph B1 of Sec. 31.34(1)(3), made after December 31, 1972. An agreement may be entered into under this section only with respect to amounts which are includable in the gross income of the employee under Section 61, and must be applicable to all such amounts paid by the employer to the employee. The amount to be withheld pursuant to an agreement under Section 3402P shall be determined under the rules contained in Section 3402 and the regulations thereunder. See Sec. 31.3405C1, Q and A3 concerning agreements to have more than 20% federal income tax withheld from eligible rollover distributions within the meaning of Section 402. B. Form and duration of agreement. 1. I accept as provided in subdivision Roman 2 of this subparagraph, an employee who desires to enter into an agreement under Section 3402P shall furnish his employer with Form W-4 withholding exemption certificate executed in accordance with the provisions of Section 3402F and the regulations thereunder. The furnishing of such Form W-4 shall constitute a request for withholding. Roman 2. In the case of an employee who desires to enter into an agreement under Section 3402P with his employer, if the employee performs services in addition to those to be the subject of the agreement, the remuneration for which is subject to mandatory income tax withholding by such employer, or if the employee wishes to specify that the agreement terminate on a specific date, the employee shall furnish the employer with a request for withholding which shall be signed by the employee and shall contain the name, address, and social security number of the employee making the request, b. the name and address of the employer, c. a statement that the employee desires withholding of federal income tax, and applicable, of qualified state individual income tax. See paragraph D3I of Sec. 301.6361-1 of this chapter, regulations on procedures and administration, and d. if the employee desires that the agreement terminate on a specific date, the date of termination of the agreement. If accepted by the employer as provided in subdivision Roman 3 of this subparagraph, the request shall be attached to, and constitute part of, the employee's Form W-4. An employee who furnishes his employer a request for withholding under this subdivision shall also furnish such employer with Form W-4 if such employee does not already have a Form W-4 in effect with such employer. Employers who hire employees who do not have Social Security numbers need to adjust their policy because the Internal Revenue Service withholding policy requires employees who complete this form to provide a taxpayer identification number (TIN) or Social Security number. The Form W-4 becomes a binding withholding agreement when it is completed by an employee and accepted by the employer. Once an employee volunteers to enter into a withholding agreement with an employer, and the employer accepts that agreement, then the employer becomes legally obligated to withhold and pay the taxes due. There is no legal authority to withhold, nor is there any other obligation in the absence of this agreement. Although there is no law, employers should advise employees who do not complete a Form W-4 that they will be responsible for paying any due taxes. These employees should be asked to sign a statement, such as the following, showing that they do not wish to enter a Roman III. No request for withholding under Section 3402P shall be effective as an agreement between an employer and an employee until the employer accepts the request by commencing to withhold from the amounts with respect to which the request was made. 2. An agreement under Section 3402P shall be effective for such period as the employer and employee mutually agree upon. However, either the employer or the employee may terminate the agreement prior to the end of such period by furnishing a signed written notice to the other. Unless the employer and employee agree to an earlier termination date, the notice shall be effective with respect to the first payment of an amount in respect of which the agreement is in effect, which is made on or after the first status determination date January 1, May 1, July 1, and October 1 of each year that occurs at least 30 days after the date on which the notice is furnished. If the employee executes a new Form W-4, the request upon which an agreement under Section 3402P is based shall be attached to, and constitute a part of, such new Form W-4. Voluntary withholding agreement, and that they understand that they lose their entitlement to certain government benefits. Complying with withholding requirements. There are no state or federal tax withholding requirements for employees who do not have Social Security numbers. However, as an employer, you should remind them that they cannot collect unemployment compensation should they be laid off. Additionally, they are responsible for paying any taxes that may be due. 26 CFR Parts 31.34 Euro 2D1 and 31.34 Euro 3-1 relate to penalties for not withholding. The first regulation pertains only to every employer required to deduct but does not create any Form W-4 Rev. November 1998. Voluntary withholding agreement termination or withdrawal from W-4 agreement. Voluntary withholding agreements. 26 CFR Section 31.34 Euro 2P1 Employer's name and address, employer identification number submitted for. In lieu of W-4, employee's withholding certificate. Employer will not make any payroll withholding. Employee is responsible for all taxes. Termination of previous W-4 agreement. Beginning effective on the last day of pay period and enter month of year. Employee's liability release statement. I type or print your name here. Understand that termination or withdrawal of a W-4 employee's withholding certificate releases the employer from any obligation to make payroll withholdings. Furthermore, I understand that I am responsible for all taxes due and I release the employer from any tax liability associated with this employee. I certify that the foregoing statement is correct, and I release the employer from any withholding obligations or claims. Employee's signature date. Employee's information type or print. Employee/payee first name and initial last name. Social Security number. Write none if you do not have it. SSN or declined if you do not wish to provide a SSN. Home address number and street or rural route. City or town, state and ZIP code Sec. 31.3402P1 Voluntary withholding agreements. In general, an employee and his employer may enter into an agreement under Section 3402B to provide for the withholding of income tax upon payments of amounts described in paragraph B1 of Sec. 31.34 Year 1-3 made after December 31, 1970. B. Form and duration of agreement. 1. I accept as provided in subdivision Roman 2 of this subparagraph. An employee who desires to enter into an agreement under Section 3402P shall furnish his employer with Form W-4 withholding exemption certificate executed in accordance with the provisions of Section 3402F and the regulations thereunder. The furnishing of such Form W-4 shall constitute a request for withholding. See a statement that the employee desires withholding of federal income tax and applicable of qualified state individual income tax. See paragraph D3I of Sec. 301.6361-1 of this chapter. Regulations on procedures and administration. And D. If the employee desires that the agreement terminate on a specific date, the date of termination of the agreement. If accepted by the employer as provided in subdivision Roman 3 of this subparagraph, the request shall be attached to, and constitute part of, the employee's Form W-4. An employee who furnishes his employer a request for withholding under this subdivision shall also furnish such employer with Form W-4 if such employee does not already have a Form W-4 in effect with such employer. Roman 3. No request for withholding under Section 3402p shall be effective as an agreement between an employer and an employee until the employer accepts the request by commencing to withhold from the amounts with respect to which the request was made. 2. An agreement under Section 3402p shall be effective for such period as the employer and employee mutually agree upon. However, either the employer or the employee may terminate the agreement prior to the end of such period by furnishing a signed written notice to the other. Unless the employer and employee agreed to an earlier termination date, the notice shall be effective with respect to the first payment of an amount in respect of which the agreement is in effect, which is made on or after the first status determination date January 1, May 1, July 1, and October 1 of each year that occurs at least 30 days after the date on which the notice is furnished. If the employee executes a new Form W-4, the request upon which an agreement under Section 3402p is based shall be attached to, and constitute a part of, such new Form W-4. Public Domain Form W-4 T-Zip Construction, Inc. 1865 Tully Road, San Jose, Calif. 9534 570 63 Tall, Brokaw through 5C72 Herman Road, Santa Cruz, Calif. Declined Tom Brokaw X Tom Brokaw 9/21/99. Obligation in itself, and only refers the second regulation, which simply refers back to the first regulation as the penalty. However, there is no penalty imposed by either regulations. The requirement and authority to deduct withholding comes only after the employer has a properly completed and signed IRS Form W-4 submitted by an employee. Complying with the INS Form I-9 requirements. Federal Law 8 U.S.C. Section 1324a makes it illegal for a person or other entity to hire, recruit, or employ an alien who is not authorized to work in the United States. The INS Employment Verification Form I-9 is implemented by regulation at 8 CFR Section 274a.2. Most employers incorrectly apply the INS Form I-9 requirement across the board with all employees and new recruits. However, the Law 8 USC Section 1324a clearly applies this issue to knowing the alien is an unauthorized alien and narrowly defines its application to an agricultural association, agricultural employer, or farm labor contractor. 8 USC Section 1324a Unlawful employment of aliens. Making employment of unauthorized aliens unlawful. 1. In general, it is unlawful for a person or other entity to hire, or to recruit or refer for a fee, for employment in the United States an alien knowing the alien is an unauthorized alien as defined in subsection H3 of this section with respect to such employment, or B.I. to hire for employment in the United States an individual without complying with the requirements of subsection B of this section, or Roman 2 if the person or entity is an agricultural association, agricultural employer, or farm labor contractor as defined in Section 1802 of Title 29, to hire, or to recruit or refer for a fee, for employment in the United States an individual without complying with the requirements of subsection B of this section. 8 CFR Section 274a.2 Verification of employment eligibility. A general. This section states the requirements and procedures persons or entities must comply with when hiring, or when recruiting or referring for a fee, or when continuing to employ individuals in the United States. For purposes of complying with Section 274a(b) of the Act and this section, all references to recruiters and referrers for a fee are limited to a person or entity who is either an agricultural association, agricultural employer, or farm labor contractor as defined in Section 3 of the Migrant and Seasonal Agricultural Worker Protection Act, 29 U.S.C. 1802. The Form I-9 Employment Eligibility Verification Form has been designated by the service as the form to be used in complying with the requirements of this section. Used only for agricultural labor. The instruction for the INS Form I-9 admits that its authority for collecting this information is AUSC 1324A. Based on that law and the implementing regulations, the INS Form I-9 is used only for an agricultural association, agricultural employer, or farm labor contractor to verify that the alien they are hiring is authorized to work in the United States. Neither the law nor the regulation authorizes its use for citizens or for employment other than an agricultural association, agricultural employer, or farm labor contractor. It is unlawful to apply this form to citizens or non-agricultural labor. Employer cannot specify which documents they accept a Social Security card may be used, but is not needed as one of the documents that establish employment eligibility. Although the Social Security number is requested on the face of the I-9 form, it is not required. Additionally, the employer is prohibited from specifying which documents are acceptable. Therefore, an employee who does not have a Social Security number may properly complete this form if he possesses one of the other documents needed to show employment eligibility. Alternative documentation. It is important to understand that the law prohibits an employer from knowingly hiring an alien who is not authorized to work in the United States and provides for positive defense if he has made copies of certain documents that the alien provides as proof of his authorization to work in the United States. The law also requires the alien to attest to their authorization under the penalty of perjury. Natural citizens cannot be compelled to prove their authorization to work. The First, Fifth, 9th and 10th Amendments of the United States Constitution prohibit the government from requiring a citizen to make an attestation or to attest under the penalty of perjury. As such, you cannot lawfully discriminate against natural citizens who assert their right to work, and the law will not protect you when those citizens seek legal recourse against you personally and your company. In fact, if you are not careful, you could become criminally liable. For example, 18 U.S.C. Section 242 and 42 U.S.C. Section 1983 provides that. This sounds like employers are being put into a ridiculously difficult situation, and to some degree that is certainly true. On one hand, the government seems to be threatening employers who fail to comply with their wishes, and on the other hand, they may get sued or even go to jail if they violate the rights of a citizen. However, when employers take the time to carefully study the law, as you are doing here, they discover that the issue is really not that complicated. Whoever, under color of any law, statute, ordinance, regulation, or custom, willfully subjects any person in any state, territory, or district to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States, shall be fined under this title or imprisoned not more than 1 year, or both. 42 U.S.C. Section 1983 further provides that a violator shall be liable to the party injured in an action at law, suit in equity, or other proper proceeding for redress. The law prohibits an employer from knowingly hiring an alien who is not authorized to work in the United States. The law does not prohibit an employer from doing any of the following: unknowingly hiring an alien who is not authorized to work in the United States, hiring an alien who is authorized to work in the United States, hiring a citizen. Additionally, the law provides for positive defense if you have obtained copies of certain documents and an attestation from the alien. In writing the positive defense clause into the law, Congress has tricked most employers into believing that this is their only positive defense choice. Of course, such is simply not true. A positive defense always exists, and we do not need Congress permission to use it. A positive defense exists if you can show any of the following: that you did not know that the employee was an alien, that you did not know that the employee was not authorized to work in the United States, that the employee is a citizen. While many people just simply do what they are asked and never assert their rights as Americans, you will occasionally find those who do. Natural citizens have many protected rights that are often forgotten or not taken seriously. You will find that most of these people understand the extra burden that our government seems to place on employers and often are willing to compromise with you in certain areas. You should consider offering the following: Sec. 1324A. Unlawful employment of aliens. A 3 defense a person or entity that establishes that it has complied in good faith with the requirements of subsection B of this section with respect to the hiring, recruiting, or referral for employment of an alien in the United States has established an affirmative defense that the person or entity has not violated paragraph 1 with respect to such hiring, recruiting, or referral. These 6 good faith compliance A in general except as provided in subparagraphs B and C. A person or entity is considered to have complied with a requirement of this subsection notwithstanding a technical or procedural failure to meet such requirement if there was a good faith attempt to comply with the requirement. Form as an alternative to the INS. Form I-9 to those citizens who assert their natural right to work. As a point of interest, employers should know that the INS has no jurisdiction over natural citizens while they are in a state. Additionally, the INS has no jurisdiction over an employer within a state who does not hire non-citizens. However, the INS may be able to assert jurisdiction if it can show that aliens do work for you. When an employee or an employer signs any government form under penalty of perjury, they have surrendered their rights and shifted the burden of proof from the government and onto themselves. This shifting of the burden of proof opens the door to INS jurisdiction. Be very cautious about signing anything under the penalty of perjury. Understanding the IRS. Form W-9 Utilization of Internal Revenue Service IRS. Form W-9, Request for Taxpayer Identification Number and Certification, is defined in 3 parts of Title 26 of the United States Code of Federal Regulations 26 CFR. According to the Internal Revenue Service Regulations, Form W-9 is used for collecting taxpayer identification associated with securities and brokerage accounts, and certain other accounts that pay interest or dividends 26 CFR 1.6401, 1.6042 and 31.3406. There is no other application authorized for use of Form W-9. It would be foolish to use the Form W-9 in any other application, because doing so suggests to the Internal Revenue Service that your relationship is in some way associated with securities or brokerage accounts, or an account that pays interest or dividends. Form P-2 Citizens Notice of Employment Eligibility in lieu of INS. Form I-9 Employment Eligibility Verification Name and Address of Citizen Name and Address of Notice Recipient Citizen's Statement. I certify that I am a free citizen of the state of and am in all ways free and authorized to work unencumbered in any state of the United States, by the right of my natural citizenship. I certify that the foregoing information stated here is true and correct. Citizen's Signature Date. Federal Law 8 U.S.C. Section 1324A make it as unlawful for a person or other entity to hire, or to recruit or refer for a fee, for employment in the United States an alien knowing the alien is an unauthorized alien with respect to such employment, or to hire for employment in the United States an individual without complying with the requirements of subsection B of this section or Roman II if the person or entity is an agricultural association, agricultural employer, or farm labor contractor, to hire, or to recruit or refer for a fee, for employment in the United States an individual without complying with the requirements of subsection B of this section. 8 CFR Section 274A.2 Verification of Employment Eligibility, a general. This section states the requirements and procedures persons or entities must comply with when hiring, or when recruiting or referring for a fee, or when continuing to employ individuals in the United States. For purposes of complying with Section 274AB of the Act and this section, all references to recruiters and referrers for a fee are limited to a person or entity who is either an agricultural association, agricultural employer, or farm labor contractor as defined in Section 3 of the Migrant and Seasonal Agricultural Worker Protection Act, 29 USC Section 1802. The Form I-9 Employment Eligibility Verification Form has been designated by the service as the form to be used in complying with the requirements of this section. Public Domain Privacy Form P-2 Zip Construction, Inc. 1865 Tully Road, San Jose, Calif. 955134 Tom, Broca 3562 Herman Road, Santa Cruz, Calif. 9560 Tom, Broca, California Tom, Broca 9/21/99. Dealing with benefits because certain deductions are not made for employees who do not have Social Security numbers. These employees fail to qualify for many benefits. Unenumerated employees should be made aware of the list of benefits that they are not entitled to, and they should be encouraged to sign an awareness statement recognizing that fact and agreeing to the loss of certain benefits as a condition of their employment. The pros and cons of hiring. The unenumerated Table 2 lists the various pros and cons of dealing with enumerated and unenumerated employees and contractors. Benefit eligible condition: unemployment compensation. No use of a social security number is required to collect unemployment compensation. Because the employee fails to qualify, the employer should not pay taxes on these programs for each unenumerated worker. Workers' compensation. Yes, employee social security number is not required for the employer's workers' compensation package if the workers' compensation is provided by a private insurance provider. However, a social security number is required for state or federal administered insurance. Social Security. No, the Social Security Administration uses the Social Security account number to track the employee's account. The employer does make co-payments to the worker's Social Security account and no money is withheld from the worker's pay. The worker has no Social Security benefits. Medical or dental insurance. Yes, employee's Social Security number is not required for private medical or dental insurance. Table 2: the pros and cons of hiring enumerated versus unenumerated issue. Enumerated. Unenumerated liability to IRS to withhold taxes. A tax liability exists with the IRS because your employees entered a W-4 agreement and you accepted the agreement to withhold. Because of the 26 U.S.C. 3402 agreement, you are liable for all taxes. Since no 26 U.S.C. 3402 tax withholding agreement exists, the employer is not liable for employee taxes. Without a W-4, each employee is liable for their own taxes. Requirement to produce records for IRS audit. Because you accepted the W-4 agreements signed under penalty of perjury, the IRS is able to force you to prove your position in an audit. Because nobody entered a W-4 withholding agreement, there is no under penalty of perjury. Statement: the IRS has no power to audit and the IRS has the obligation to prove their case. Requirement to appear for an IRS summons. Because of the under penalty perjury testaments, you are obligated to appear and prove your case. The IRS is obligated to prove their case in a regular court of law and any summons must conform that court. Requirement to appear for an IRS hearing. Because of the under penalty perjury testaments, you are obligated to appear and prove your case. The IRS is obligated to prove their case in a regular court of law and any summons must conform that court. Requirement to issue W-2s. The law requires you to issue W-2s to each employee. You are prohibited from issuing a W-2 because of the W-2 requirement for a Social Security number. Requirement to issue 1099s. The law requires you to issue 1099 to each non-employee. You are prohibited from issuing a 1099 because of the 1099's requirement for a Social Security number. Burden of proof in tax matters. Signature under penalty of perjury places the burden of proof upon the signer. Since there is no under penalty of perjury signature, the burden of proof exists with the IRS. Accounting/bookkeeping requirements required for tax withholding. Much easier because there is no tax withholding. Susceptibility to IRS liens and levies. Highly susceptible because of the under penalty of perjury. Signatures impossible without a trial and court order. Susceptibility to INS intrusion. Highly susceptible because of the under penalty of perjury. Signatures impossible without a trial and court order. Why does my CPA disagree with you? A huge specialized market exists in tax compliance issues and most of our accounting practices are closely tied to income tax compliance. The success of the accounting business is largely related to the complexity of the Internal Revenue Service laws and regulations. Many of these CPAs and tax attorneys are also enrolled agents. An enrolled agent is an individual who has successfully completed United States Department of the Treasury monitored training programs and received Internal Revenue Service certification in representing Internal Revenue Service tax law. Enrolled agents help you pay taxes and comply with the desires, not necessarily the law of the Internal Revenue Service. Enrolled agents are trained and certified by the Internal Revenue Service to do exactly what the Internal Revenue Service wants. Enrolled agents are often rewarded by the Internal Revenue Service by keeping their clients involved with the tax problems. The majority of clients who use enrolled agents receive more Internal Revenue Service notices and letters than people who don't use them. Susceptibility to employee retaliation increased likelihood because most enumerated employees are protected by various government programs, unlikely because employees received higher pay and signed employment agreements acknowledging the lack of certain benefits. Risk of employee lawsuit increased likelihood because most enumerated employees are protected by various government programs, unlikely because employees received higher pay and signed employment agreements acknowledging the lack of certain benefits. Effect on employee morale: the same old routine. Employees respond better and have greater morale because of higher pay. Effect on employee allegiance: the same old routine. Employees appreciate their employer greater, show stronger allegiance, and are likely to remain with their current employer. Effect on employee productivity: the same old routine. Employees produce more and better because of higher pay. Assets protection: less asset protection because of you increased exposure to IRS audit and liens. Greater asset protection because of IRS obligation to prove their case in each instant. Effect on the bottom line: the same old routine. Improved effect on bottom line due to higher employee productivity and lower risk of government intrusion. Issue: enumerated, unenumerated. CPAs and most tax attorneys will not tell you about the issues we discuss because their financial success is tied to the complexity of income tax law and to keeping you in the system. When people and businesses discover how to sever the strings that tie them into this corrupt system, they no longer need the assistance of these so-called specialists and usually fire them. These specialists do not tell you about these laws that you are now reading for yourself because they fear that they will lose your business. You are tied to the system by the laws that they choose to tell you about, the complexity of those laws, and the fear of Internal Revenue Service retaliation. Most tax specialists know that there is no law requiring a person to obtain and use a Social Security number and will confirm that fact if you ask them directly. They will also tell you that you should fire any employee who does not have a Social Security number, and that they will no longer help you if you don't. Understand, that is the same thing as saying, yeah, we know the law, but we're not going to help you comply with the law. Perhaps you should ask your tax specialist some direct questions and then you can decide who you really trust. Ask them about the following. Can you show me the law that requires a person to obtain a Social Security number? Can you show me the law that makes an IRS Form W-4 mandatory? Can you show me the law that requires me to have an INS Form I-9 on file for each non-agribusiness employee? Can you show me the law that requires me to withhold employee tax money without a W-4? Can you explain the legal process for hiring a person who has no Social Security number? Can you show me the law that exempts me from penalties if I don't get an employee's Social Security number? Getting hired without a Social Security number: every person hoping to be hired needs to understand that most employers are hiring employees because they want to make more money. For that reason, employers need to hire a person that will produce at a level that makes the employer more money than they spend as a result of hiring that person. Therefore, employers need employees who are not only productive, but honest, reliable, and diligent as well. Additionally, employers don't hire people who might bring other problems to the job, such as Internal Revenue Service inquiries. As a potential employee, you need to understand that given equal or even slightly better skills, an employer who understands their right to hire you and the legal protection provided to him is still likely to hire the enumerated employee. As a person who has decided to assert your legal right to not obtain or use a Social Security number, you will, if you haven't already, quickly learn that it is rapidly becoming increasingly difficult to live free. In many ways, you must exercise greater responsibility in your various personal, legal, and civic duties than most other Americans. Unlike other Americans, you realize that you are totally responsible for your actions and future. You responsibly pay all the taxes you owe, and realize that you must prepare for your own retirement because you cannot collect Social Security or Medicare benefits. Most enumerated people believe that American life is too difficult without a Social Security number and have surrendered their rights in return for government security in old age. You can more easily decide what is important to you after reviewing Table 3, which lists the pros and cons for many of the issues. Table 3: Pros and cons of having or not having a Social Security number. Issues: enumerated, unenumerated. Banking: easier, because bankers have been tricked or intimidated into enforcing non-existent law. Banking is more difficult because few Americans assert their lawful rights. Credit: not an issue. It is slightly more difficult to establish a credit history without a Social Security number. It is no longer an issue once your good credit history is established. Education not an issue unless you are seeking a federal student loan. Employment easier because employers have been tricked or intimidated into enforcing non-existent law. Employment is more difficult because few Americans assert their lawful rights. Federal home mortgage not an issue, not eligible. Federal license not an issue. Food stamps not an issue, not eligible. Independence restricted because of their requirement to provide the social security number that was assigned to them. Greater independence because more laws provide protection against expecting the unenumerated to provide a number that they don't have. Insurance not an issue. Medical care not an issue. Medicare eligible for Medicare payments that are too small to cover most needs. Old age benefits, even with SSI, are not sufficient to meet the extra cost. Not eligible, but because your retirement account provides a higher standard of living, you can easily afford private insurance that meets all of your medical needs. Military service not an issue. Federal law prohibits the military from requiring a social security number. The military will provide its own service number for those who do not have social security number. Old age benefits, the enumerated pay about 16% of their income for their entire working life, so that they might be able to collect about $600 a month in old age benefits. Allowed to save freely, unencumbered by additional taxation, for their own retirement. Saving at the enumerated rate will net them a retirement fund of more than $225.00 a month. Privacy, much less control of their privacy, and are exposed to greater risk of financial fraud. Assert a tremendous control over their privacy. SBA loans not an issue. Selective service registration difficult for young males to avoid registering for the draft because their social security number is well established in federal databases. The law allows you to register. However, it is nearly impossible to catch you and prosecute if you fail to register. State license not an issue. New federal regulation causing states to pass new laws are making it more difficult for you to assert your rights. Student loan may be eligible for federal student loan program. Males must register for the draft. Not eligible for federally subsidized student loans. Taxation required, and unavoidable. IRS computers are not able to track the unenumerated. You must voluntarily meet any obligation for which you may be liable. Unemployment benefits, the enumerated employer pays the employee less so they can pay for state unemployment insurance. No state unemployment insurance available. Veteran benefits not an issue. Your military service number is used. Veteran educational benefits not an issue. Your military service number is used. Veteran home loans not an issue. Your military service number is used. Issues enumerated, unenumerated. Negotiating with a prospective employer. Many unenumerated employees believe that they must work under the table for very low wages. This assumption has caused a lot of unnecessary hardship for many naive people and has resulted in tremendous savings for many unscrupulous employers. This assumption is absolutely incorrect. Employers who hire unenumerated employees have fewer payroll deductions, which result in a 20 to 40% saving for each employee and lower operating overhead. Simply because of this savings, employers should pay unenumerated workers more than their enumerated counterpart. Of course, they probably won't want to do that, but to be fair, the employer needs to recognize that you do not enjoy many of the other so-called benefits such as unemployment compensation. Therefore, it is reasonable that you should negotiate a pay that is at least 20% above that of enumerated peer employees. Employers should find this a comfortable compromise. However, with that aside, you will discover that it is very difficult to find employers who will take the time to learn about hiring the unenumerated employee. For those that do learn, few will have the courage to do it. There are basically two ways to approach this. The first way is to simply go to a prospective employer and fill out the employment application as any other potential employee would. With a pencil, write this note in the Social Security number request field: necessary information provided upon offer of employment. You will need to overwrite the area a bit to fit all of that in, but the personnel people will usually assume that you have your reasons. If they ask, tell them that since the information isn't really needed until you are hired 26 CFR Section 6011B2C6, that for security reasons you would like to withhold that information until it become absolutely necessary. They will usually agree. This will permit you to proceed through the interview process and to receive a real employment offer. If they do not offer to hire you, it is because they found someone they feel more comfortable with and not because of a social security number issue. When they do make you an employment offer, it is because you're the qualified candidate that they want. Soon after their employment offer, they will ask you for a social security number, and you now have an opportunity to explain why you don't have one and how they should proceed. Hopefully their legal department will study the issue carefully and make the necessary arrangements. You may offer copies of the appropriate forms available in this manual, and you should be willing to sign those agreements. If they fire you, then you know clearly that it is because they choose to discriminate against you for being unenumerated. You might wish to proceed with the Equal Employment Opportunity Commission or in court. The second method is to briefly explain your unenumerated status in a cover letter accompanying your resume. You will get very few positive responses from your resume, but those that do come back will be extremely promising because they understand the issue before interviewing you. This process is most effective when you have very useful or necessary skills. It is also best received by smaller employers or in smaller communities. Don't use a false social security number. Some people suggest that using a false social security number or using a number that was assigned to someone else may be a reasonable solution for the unenumerated or for somebody who wishes to withhold a social security number. Using a false or fraudulent social security number is not only a bad idea, but may get you into big trouble. Federal law defines several circumstances where using a false social security number is criminal fraud, and there are numerous cases where the individuals doing this have been convicted of fraud and sent to prison. While you are not likely to be convicted of fraud for attempting to use a false social security number during or for the purpose of employment, you are likely to be quickly discovered and fired if you fail to correct the number. The Social Security Administration provides several services that assist employers who wish to verify that a name and social security number match that which was assigned by the Social Security Administration. When the employer uses this service and discovers that the social security number you gave him does match with the information you provided, he will ask you to correct the records. The employer may fire you if he suspects you attempted to lie to him on your employment application. Although specifically dealing with the administration of employees' benefits, Federal Regulation 20 CFR Section 422.108 does provide criminal penalties for misrepresentation of social security numbers. Dealing with the INS Form I-9 as discussed earlier, most employers incorrectly apply the INS Form I-9 requirement upon all employees and new recruits. However, the law, 8 USC Section 1324A, clearly applies this issue to knowing the alien is an unauthorized alien and narrowly defines its application to an agricultural association, agricultural employer, or farm labor contractor. If your job application is in the field of agribusiness, it is probably best to simply comply with the employer's request. Of course, as a natural-born citizens, you may lawfully protest the issue if you wish. However, you should assert good judgment here, since such a protest might result in a job loss. Since the notice on this form restricts the employer from dictating which documents may be used, simply leave the Social Security number field blank. People hired in non-agribusiness fields should protest using the INS Employment Verification Form I-9 because it implies, according to federal law, that you are being employed in agribusiness. Additionally, since you are attesting to the information under penalty of perjury, you are obligating yourself to proving your citizenship to an INS 20 CFR Section 422.108 criminal penalties. A person may be subject to criminal penalties for furnishing false information in connection with earnings records or for wrongful use or misrepresentation in connection with Social Security numbers, pursuant to Section 208 of the Social Security Act and sections of Title 18 U.S.C. 42 U.S.C. 408, 18 U.S.C. 1.1 and 546. Officer, should he ask you? Without your signature, the burden of proof lies solely with the INS, and their questioning you could easily become harassment. Don't surrender your rights so easily. Serving notice: the best way to handle this is to make a copy of the regulation written below and give that copy to the person asking you complete the form. Tell them that they are using the form incorrectly, and they are asking you to violate the law. Since federal law prohibits an employer from knowingly hiring an unauthorized alien, it would be prudent for you to offer your employer a signed testament that you are a lawful resident or a natural-born citizen. You might include a copy of your birth certificate or some other proof with that testament. You may use one of the appropriate samples from sample letters and forms on page 209. If the employer is adamant about expecting you to sign an INS, Form I-9, and thus surrender your rights as a citizen, then you might consider serving them with a copy of the following document. You should complete 2 copies of this form and serve one to the employer and keep a copy for your own records. Since employers, like most people, really 8 CFR Section 274A.2 Verification of Employment Eligibility. A general. This section states the requirements and procedures persons or entities must comply with when hiring, or when recruiting or referring for a fee, or when continuing to employ individuals in the United States. For purposes of complying with Section 274AB of the Act and this section, all references to recruiters and referrers for a fee are limited to a person or entity who is either an agricultural association, agricultural employer, or farm labor contractor as defined in Section 3 of the Migrant and Seasonal Agricultural Worker Protection Act, 29 U.S.C. 1802. The Form I-9, Employment Eligibility Verification Form, has been designated by the service as the form to be used in complying with the requirements of this section. Hate being officially served legal notices. You should consider that doing this will drastically reduce your chances of being hired. Dealing with the IRS Form W-4 as explained earlier. Most employers believe you have a legal obligation to complete an Internal Revenue Service Form W-4 and will threaten to withhold from your paycheck as though you are a single person without one. This issue is best handled by using the appropriate samples from sample letters and forms on page 209 and sending that notice to your employer's legal or accounting department. You may also find the voluntary withholding agreement on page 224 helpful. Dealing with rejection living unenumerated mean that you will endure more rejection than most other people. There are several options available to you when you are rejected by an employer. Forget it and move on. Although our first instinctive response is to protect ourselves and get even, it is not always the best or wisest choice. The first option we should always consider is to simply forget it and form P3 Citizens Notice of Employment Eligibility in lieu of INS. Form I-9 Employment Eligibility Verification Name and Address of Citizen Name and Address of Notice Recipient Citizen Statement. I certify that I am a free citizen of the state of and am in all ways free and authorized to work unencumbered in any state of the United States by the right of my natural citizenship. I certify that the foregoing information stated here is true and correct. Citizen's signature date legal notice and warning. Federal law provides that it is a crime to violate the rights of a citizen under the color of law. You can be arrested for this crime and you can also be held personally liable for civil damages. Federal regulation, CFR Section 274A.2, restricts the use INS. Form I-9 to certain employers involving the use of agricultural workers. The I-9 form has no other application and is not authorized for use with natural citizens of the United States. Notice of service. I certify that personally delivered this notice to above-named recipient and address on enter date here at time. Federal law, 8 U.S.C. Section 1324A makes it unlawful for a person or other entity to hire, or to recruit or refer for a fee, for employment in the United States an alien knowing the alien is an unauthorized alien with respect to such employment, or to hire for employment in the United States an individual without complying with the requirements of subsection B of this section or Roman II if the person or entity is an agricultural association, agricultural employer, or farm labor contractor, to hire, or to recruit or refer for a fee, for employment in the United States an individual without complying with the requirements of subsection B of this section. 8 CFR Section 274A.2 Verification of Employment Eligibility, a general. This section states the requirements and procedures persons or entities must comply with when hiring, or when recruiting or referring for a fee, or when continuing to employ individuals in the United States. For purposes of complying with Section 274AB of the Act and this section, all references to recruiters and referrers for a fee are limited to a person or entity who is either an agricultural association, agricultural employer, or farm labor contractor as defined in Section 3 of the Migrant and Seasonal Agricultural Worker Protection Act, 29 USC Section 1802. The Form I-9 Employment Eligibility Verification Form has been designated by the service as the form to be used in complying with the requirements of this section. 18 U.S.C. Section 242 and 42 U.S.C. Section 1983 provides that whoever, under color of any law, statute, ordinance, regulation, or custom, willfully subjects any person in any state, territory, or district to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States, shall be fined under this title or imprisoned not more than 1 year, or both. 42 U.S.C. Section 1983 further provides that a violator shall be liable to the party injured in an action at law, suit in equity, or other proper proceeding for redress. Public Domain Privacy Form P3022 Greg Morris, Web TV Networks, 11295 Charleston Road, Mountain View, CA, 94543 Tom, Brokaw 3, 5672 Herman Road, Santa Cruz, Calif. 95060 Tom, Brokaw, California Tom, Brokaw 9/22/99 10:30 a.m. Use a new form for each person and company that you serve. Be sure to keep a copy for your records. Tom Brokaw 9/22/99. Move on with life. Although being fired from a job simply because you choose to live unenumerated is neither fair nor legal, simply forgetting it and moving on with things is the easiest and less stressful way of dealing with it. Certainly we can sue the people who treat us unjustly or unlawfully, but suing takes a lot of time, energy, and resources. Litigation seldom results in the outcome we hope for and usually just adds to make the situation more stressful. File criminal charges. Many times the unenumerated are unknowingly victims of a crime. The most notable example of this is when someone tells you that you must have, or you must provide a social security number because it is the law. Most often the statement that it is the law is a criminal violation of the law, which if proven, could subject the person who said it to fines and jail. For example, 18 U.S.C. Section 242 and 42 U.S.C. Section 1983 provides that. And 42 U.S.C. Section 408 provides that. If these crimes are committed against you, and you can prove it, then you need to talk to your local district attorney about filing a criminal complaint. If your evidence has merit, then the local district attorney is legally obligated to pursue the case. Sue for violating your rights or for discrimination. Civil litigation is the most common route taken by people who wish to assert their legal right to work in the United States unenumerated. There are 2 ways to pursue this course. The first is to file a complaint with Equal Employment Opportunity Commission for discrimination based upon some protected rights such as freedom of religion. Filing a charge with the Equal Employment Opportunity Commission if you believe you have been discriminated against by an employer, labor union, or employment agency when applying for a job or while on the job because of your race, color, sex, religion, national origin, age, or disability, or believe that you have been discriminated against because of opposing a prohibited practice or participating in an equal employment opportunity matter, you may file a charge of discrimination with the United States Equal Employment Opportunity Commission. Charges may be filed in person, by mail, or by telephone by contacting the nearest Equal Employment Opportunity Commission office. If there is not an equal employment, whoever, under color of any law, statute, ordinance, regulation, or custom, willfully subjects any person in any state, territory, or district to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States, shall be fined under this title or imprisoned not more than 1 year, or both. 42 U.S.C. Section 1983 further provides that a violator shall be liable to the party injured in an action at law, suit in equity, or other proper proceeding for redress. Whoever 8 discloses, uses, or compels the disclosure of the Social Security number of any person in violation of the laws of the United States shall be guilty of a felony and upon conviction thereof shall be fined under Title 18 or imprisoned for not more than 5 years, or both. Opportunity Commission Office in the immediate area. Call toll-free not 1669 4 or 8 69 68 and 2 TDD for more information. To avoid delay, call or write beforehand if you need special assistance, such as an interpreter, to file a charge. There are strict time frames in which charges of employment discrimination must be filed. To preserve the ability of Equal Employment Opportunity Commission to act on your behalf and to protect your right to file a private lawsuit, should you ultimately need to, adhere to the following guidelines when filing a charge. Title Roman 7 of the Civil Rights Act charges must be filed with Equal Employment Opportunity Commission within 180 days of the alleged discriminatory act. However, in states or localities where there is an anti-discrimination law and an agency authorized to grant or seek relief, a charge must be presented to that state or local agency. Furthermore, in such jurisdictions, you may file charges with Equal Employment Opportunity Commission within 300 days of the discriminatory act, or 30 days after receiving notice that the state or local agency has terminated its processing of the charge, whichever is earlier. It is best to contact Equal Employment Opportunity Commission promptly when discrimination is suspected. When charges or complaints are filed beyond these time frames, you may not be able to obtain any remedy. Facts about religious discrimination. Title Roman 7 of the Civil Rights Act of L. 964 prohibits employers from discriminating against individuals because of their religion in hiring, firing, and other terms and conditions of employment. The Act also requires employers to reasonably accommodate the religious practices of an employee or prospective employee, unless to do so would create an undue hardship upon the employer. See also 29 CFR Section L. 605. Flexible scheduling, voluntary substitutions or swaps, job reassignments, and lateral transfers are examples of accommodating an employee's religious beliefs. Employers cannot schedule examinations or other selection activities in conflict with a current or prospective employee's religious needs, inquire about an applicant's future availability at certain times, maintain a restrictive dress code, or refuse to allow observance of a Sabbath or religious holiday, unless the employer can prove that not doing so would cause an undue hardship. An employer can claim undue hardship when accommodating an employee's religious practices if allowing such practices requires more than ordinary administrative costs. Undue hardship also may be shown if changing a bona fide seniority system to accommodate one employee's religious practices denies another employee the job or shift preference guaranteed by the seniority system. An employee whose religious practices prohibit payment of union dues to a labor organization cannot be required to pay the dues, but may pay an equal sum to a charitable organization. Mandatory New Age training programs, designed to improve employee motivation, cooperation, or productivity through meditation, yoga, biofeedback, or other practices, may conflict with the non-discriminatory provisions of Title Roman 7. Employers must accommodate any employee who gives notice that these programs are inconsistent with the employee's religious beliefs, whether or not the employer believes there is a religious basis for the employee's objection. Going on your own while starting your business or being self-employed is difficult for many of us. It is probably the easiest and least stressful alternative for the unenumerated to consider. One of the greatest blessings of living in America is all of the fantastic opportunity available to anybody who has a little bit of imagination, a lot of drive and self-discipline, and who is willing to work hard for their own personal reward. For a lot less energy than the unenumerated spend trying to educate prospective employers, dealing with a rejection and considering their options, most of us can begin a new career by discovering a special market niche in our community and filling it. It may be as simple as marketing your professional talents as a consultant, or perhaps you may have been thinking about changing careers, providing paralegal services, or doing landscape maintenance. If you have some cash set aside, maybe it's time to open a small store or shop. There are many very good books available for people who are thinking about going it on their own. We recommend that you visit your local bookstore and review some of these. Starting your own business is a very important decision that should be studied carefully. If done right, it will be the most personal and financially rewarding experience of your life. Individual Taxpayer Identification Number. A final note for this section is a scam warning. Many promoters suggest that you can get around the Social Security number issue by claiming they are not citizens of Washington, D.C. and are therefore aliens in the view of federal law. Without trying to explain their logic, they further assert that an alien individual should in fact obtain and use an individual taxpayer identification number instead of a Social Security number. Their assertion is simply wrong. The Individual Taxpayer Identification Number (ITIN) is a tax processing number that became available July 1, 1996, for certain non-resident and resident aliens, their spouse, and dependents. The Individual Taxpayer Identification Number is only available to individuals who cannot get a Social Security number. The Individual Taxpayer Identification Number is not applicable since any citizen of any state living in the United States can apply for and receive a Social Security number. 39. Financial issues. Financial institutions are tightly regulated by federal law, primarily United States Code Title 12, Banks and Banking, and Title 31, Money and Finance, and often refer clients to various laws and regulations as their reason for doing or not doing certain things. When an unenumerated citizen attempts to enter a relationship with a financial institution, they are usually rejected because the institution wrongly believes that federal law requires them to obtain a Social Security or taxpayer ID number from each customer. Financial institutions usually respond with a canned statement such as, however, getting away with such claims tends to also mean that financial institutions rely heavily upon the naivete and gullibility of customers and bankers' ability to intimidate customers with legal citations. When challenged more specifically, the bankers often turn to their 3-volume legal reference published by the Federal Deposit Insurance Corporation called FDIC Law, Regulations and Related Acts, where we read, 31 CFR 103.34 and 26 U.S.C. 6109 require that you provide your Social Security number when opening an account. Additionally, according to instructions published in the Federal Register 37 FR 13270, 37 FR 26517, 38 FR 3341, and 39 FR 32336, financial institutions are required to obtain your Social Security number before opening an account. 8,000 Miscellaneous Statutes and Regulations. Department of the Treasury instructions relating to taxpayer identification numbers, financial recordkeeping and reporting of currency and foreign transactions. Instructions relating to taxpayer identification numbers on June 30, 1972. Instructions were issued on this subject and published in the Federal Register 37 FR 13279 1972. These procedures have been revised in accordance with amendments to the regulations issued on December 8, 1972, and published in the Federal Register 37 FR 26517 1972. With respect to each deposit or share account opened after June 30, 1972, by a person residing or doing business in the United States or a citizen of the United States, each bank, savings and loan association, building and loan association, credit union, or broker or dealer in securities must, within 45 days from the date the account is opened, secure and maintain a record of the taxpayer identification number of the person maintaining the account. For individuals, the taxpayer identification number is his Social Security number. For corporations, partnerships, and other entities, it is the IRS Employer Identification Number. If an account is opened in more than one individual's name, the financial institution is required to secure and maintain the Social Security number of at least one individual having a financial interest in that account. In determining the proper identification number to be obtained for accounts opened in more than one name, the financial institution should follow the regulations and rulings issued by the Internal Revenue Service under Section 6109 of the Internal Revenue Code. The following guidelines have been issued by IRS under that section. With respect to accounts opened for trusts, charitable organizations, clubs, and similar entities, the financial institution should secure the employer identification number of the entity. An employer identification number should be obtained for this purpose even though an organization might not otherwise require one. A taxpayer identification number need not be secured in the following instances. I. Accounts for public funds opened by agencies and instrumentalities of federal, state, local or foreign governments. II. Accounts for aliens who are ambassadors, ministers, career diplomatic, or consular officers, or B. Naval, military or other attaches of foreign embassies and legations, and for the members of their immediate families. III. Accounts for aliens who are accredited representatives to international organizations entitled to enjoy privileges, exemptions, and immunities as an international organization under the International Organizations Immunities Act of December 29, 1945, 22 U.S.C. Sec. 288. And for the members of their immediate families. A list of such organizations appears in Title 19, Section 148.87, formerly Section 10.30a, Code of Federal Regulations, IV. Aliens temporarily residing in the United States for a period not to exceed 180 days. The aliens not engaged in a trade or business in the United States who are attending a recognized college or university or any training program supervised or conducted by any agency of the federal government. Roman 6 Unincorporated subordinate units of a tax-exempt central organization which are covered by a group exemption letter. Roman 7 Interest-bearing accounts maintained by a person 18 years of age opened as part of a school thrift savings program, provided the annual interest does not exceed $10, and Roman 7 Christmas Club, Vacation Club, and similar installment savings programs provided the annual interest does not exceed $10. In instances Roman 7 and Roman 8, the bank shall, within 15 days following the end of any calendar year in which the interest accrued in that year exceeds $10, use its best efforts to secure and maintain the appropriate taxpayer identification number or application form therefor. If the customer does not have a Social Security number or is unaware of his number, he can authorize the Social Security Administration to furnish his identification number to the financial institution. This authorization may be printed or stamped on the back of Form SS-5 application for Social Security No. in the space immediately above the legend, for Bureau of Data Processing and Accounts use. The authorization must contain the following language. Please furnish my SSN to name, address, signature. The customer should complete Form SS-5 and sign the statement on the back of the form. The financial institution should mail the completed form to the Social Security Administration in the pre-addressed envelope provided and retain a copy, duplicate, or photocopy of the application until the number is received. The Social Security Administration does not require the Form SS-5 or the authorization statement to be signed by a parent or guardian even though the customer is under 18 years of age. A similar procedure may be used to obtain employer identification numbers. Upon proper authorization by the applicant on the back of Part 2 on the first page of Form SS-4 Application for Employer Identification No. The IRS will furnish the employer identification number to both the applicant and the financial institution. Financial issues 41. Financial institutions may obtain supplies of Form SS-5 and pre-addressed envelopes from their nearest Social Security office, and supplies of Form SS-4 and pre-addressed envelopes from any Internal Revenue Service Center or district office. In the event that a financial institution has been unable to secure the identification required herein with respect to an account within the 45-day period specified, it shall nevertheless not be deemed to be in violation of this requirement if it has made a reasonable effort to secure such identification, and Roman 2 it maintains a list containing the names, addresses, and account numbers of those persons from whom it has been unable to 6-30-98p.9597 secure such identification, and makes the names, addresses, and account numbers of those persons available to the Secretary as directed by him. A reasonable effort to obtain a taxpayer identification number should include the mailing of a written request. The request should inform the customer that the bank is required to maintain, for the use of the Department of the Treasury, a list of customers who have failed to supply the bank with a TIN within the 45-day period. The 45-day period provided for shall be extended where the customer has applied for an employer identification number or Social Security number on Form SS-4 or SS-5 until such time as the customer has had a reasonable opportunity to secure the number and furnish it to the institution. Dated January 30, 1973. Source: 38 Fed. Reg. 3341, February 5, 1973. Treasury Notice of Revision of Instructions on January 31, 1973. Instructions were issued on this subject and published in the Federal Register 38 FR 3341 1973. These instructions have been revised herein to reflect changes in Social Security Administration procedures governing the issuance of Social Security numbers. The Social Security Administration now generally requires evidence of age, citizenship, and identity of applicants for Social Security numbers. Therefore, the Social Security Administration will no longer honor requests for numbers by financial institutions on behalf of customers. Financial institutions must, within 45 days after an account is opened, secure and maintain a record of taxpayer identification numbers of customers opening share or deposit accounts after June 30, 1972. For individuals, the taxpayer identification number is his Social Security number. If an account is opened in more than one individual's name, The financial institution should secure and maintain the social security number of at least one individual having a financial interest in that account. For corporations, partnerships, and other entities, it is the IRS Employer Identification Number. Instances in which a taxpayer identification number need not be secured remain as printed in the Federal Register 38 FR 341 1973. If a financial institution has been unable to secure the required identification number within the 45-day period, it shall be in compliance with this requirement if it has made a reasonable effort to secure the number, and Roman II it maintains a list containing the names, addresses, and account numbers of those persons for whom it has been unable to secure an identification number and makes the names, addresses, and account numbers of those persons available to the Secretary as directed by him. While this is an interesting historical reference, it is not the law, and reliance upon it as law is dangerous. Immediately after being published in the Federal Registers, these regulations were also published in the Code of Federal Regulations. When citing laws and regulations, bankers would be wise to refer to a current copy of the United States Code or the Code of Federal Regulations where the statute reflects the currently enforceable laws and regulations. However, the above historical information copied from the Federal Register more than 20 years ago and the current regulation both reflect the requirement that the financial institution must request a Social Security number or taxpayer ID number when opening an account, and that the financial institution is not in violation of the law or regulation if they made a reasonable effort to get an identity number. Additionally, you should note that the FDIC law, regulations, and related acts also contain the following Privacy Act notification. A reasonable effort to obtain a taxpayer identification number should include the mailing of a written request. The request should inform the customer that the bank is required to maintain, for the use of the Department of the Treasury, a list of customers who have failed to supply the financial institution with a TIN within the 45-day period. Dated August 30, 1974. Source: 39 Fed. Reg: 32,336, September 6, 1974. 8,000 Miscellaneous Statutes and Regulations. Findings and Purpose of the Privacy Act of 1974. Section 2 of the Act of December 31, 1974. Pub. L. No. 93-579. 88 Stat. 1896, which enacted Section 552A of Title V, United States Code, provides as follows. Sec. 2. The Congress finds that when the privacy of an individual is directly affected by the collection, maintenance, use, and dissemination of personal information by federal agencies, to the increase in use of computers and sophisticated information technology, while essential to the efficient operations of the government, has greatly magnified the harm to individual privacy that can occur from any collection, maintenance, use, or dissemination of personal information. 3. The opportunities for an individual to secure employment, insurance, and credit, and his right to due process, and other legal protections are endangered by the misuse of certain information systems. 4. The right to privacy is a personal and fundamental right protected by the Constitution of the United States. And 5. In order to protect the privacy of individuals identified in information systems maintained by federal agencies, it is necessary and proper for the Congress to regulate the collection, maintenance, use, and dissemination of information by such agencies. B. The purpose of this act is to provide certain safeguards for an individual against an invasion of personal privacy by requiring federal agencies, except as otherwise provided by law, to 1. Permit an individual to determine what records pertaining to him are collected, maintained, used, or disseminated by such agencies. This portion of the law remains intact and is codified in the current United States Code in several places, including a specific application to the banks and financial institution. 2. Permit an individual to prevent records pertaining to him obtained by such agencies for a particular purpose from being used or made available for another purpose without his consent. 3. Permit an individual to gain access to information pertaining to him in federal agency records, to have a copy made of all or any portion thereof, and to correct or amend such records. 4. Collect, maintain, use, or disseminate any record of identifiable personal information in a manner that assures that such action is for a necessary and lawful purpose, that the information is current and accurate for its intended use, and that adequate safeguards are provided to prevent misuse of such information. 5 permit exemptions from the requirements with respect to records provided in this Act only in those cases where there is an important public policy need for such exemption as has been determined by specific statutory authority. And 6. Be subject to civil suit for any damages which occur as a result of willful or intentional action which violates any individual's rights under this Act. Disclosure of Social Security account numbers. Section 7 of the Act of December 31, 1974 Pub. L. No. 93-579. 88 Stat. 99, effective December 31, 1974, provides as follows. Sec. 7. 1. It shall be unlawful for any federal, state, or local government agency to deny to any individual any right, benefit, or privilege provided by law because of such individual's refusal to disclose his Social Security account number. 2. The provisions of paragraph 1 of this subsection shall not apply with respect to any disclosure which is required by federal statute, or b. The disclosure of a Social Security number to any federal, state, or local agency maintaining a system of records in existence and operating before January 1, 1975, if such disclosure was required under statute or regulation adopted prior to such date to verify the identity of an individual. b. Any federal, state, or local government agency which requests an individual to disclose his Social Security account number shall inform that individual whether that disclosure is mandatory or voluntary, by what statutory or other authority such number is solicited, and what uses will be made of it. 31 U.S.C. Section 1.32 Use and disclosure of Social Security numbers. A. In general, an individual shall not be denied any right, benefit, or privilege provided by law by a component because of such individual's refusal to disclose his Social Security number. B. Exceptions. The provisions of paragraph of this section shall not apply with respect to 1. Any disclosure which is required by federal statute, or 2. The disclosure of a Social Security number to any federal, state, or local agency maintaining a system of records in existence and operating before January 1, 1975, if such disclosure was required under statute or regulation adopted prior to such date to verify the identity of an individual. This law clearly states that in the matter of money and finance that an individual shall not be denied any right, benefit, or privilege provided by law by a component because of such individual's refusal to disclose his Social Security number. A new area of law that the banks and financial institutions are attempting to enforce is the requirement that the federal government has put upon the states to create laws that are beyond the legal limits of congressional authority. That is, Congress is attempting to force the states to do that which they cannot legally do themselves. Of course, they neglect to recognize that if the federal Congress cannot do it, then the state cannot do it either. However, regardless of the constitutional authority, or lack thereof, these new laws are causing additional difficulty for the unenumerated. However, this section only defines the procedures under which the state agency shall enter into agreements with financial institutions. It contains no provisions for collecting or requiring identification numbers from customers. See Requests for Disclosure of Social Security Number. Any component which requests an individual to disclose his or her Social Security account number shall inform that individual whether 1. Disclosure is mandatory or voluntary, 2. By what statutory or other authority such number is solicited, and 3. What uses will be made of it. See Section 7 of the Privacy Act of 1974 set forth at 5 U.S.C. 552a, note 42 USC Section 666. Requirement of statutorily prescribed procedures to improve effectiveness of child support enforcement. Types of procedures required. 17 Financial institution data matches. In general, procedures under which the state agency shall enter into agreements with financial institutions doing business in the state to develop and operate, in coordination with such financial institutions, a data match system, using automated data exchanges to the maximum extent feasible, in which each such financial institution is required to provide for each calendar quarter the name, record address, Social Security number or other taxpayer identification number, and other identifying information for each non-custodial parent who maintains an account at such institution and who owes past due support, as identified by the state by name and Social Security number or other taxpayer identification number, and Roman II in response to a notice of lien or levy, encumber or surrender, as the case may be, assets held by such institution on behalf of any non-custodial parent who is subject to a child support lien pursuant to paragraph 4. Financial institutions also frequently cite 26 U.S.C. Section 6109 as their reliance for the Social Security number mandate. This law requires the financial institution to request from certain customers that they include that identifying number on applicable returns. The law also states that a customer shall furnish to such other person the financial institution such identifying number as may be prescribed. This confusing statement does not demand a customer to furnish an identifying number, see definition for shall at beginning of this manual, but is instead telling the customer which number he shall use, should he choose to furnish it. There is no mandate within this section requiring a customer to obtain a Social Security number, so he can provide it to the financial institution, and there is no requirement for an unenumerated person to provide a Social Security number. Additionally, the Internal Revenue Code and regulations do not contain an absolute requirement that any financial institution must provide the customer's Social Security number to the Internal Revenue Service. The regulation interpreting 26 U.S.C. Section 6109 provides, the applicable federal statute and regulation place a duty on the financial institution to request a taxpayer identifying number from the customer. However, after requesting the number, if the financial institution is still unable to obtain an identifying number from the customer, then the financial institution only needs to include an accompanying affidavit stating that the request for the number was made. 26 U.S. Section 6109. Identifying numbers. A supplying of identifying numbers when required by regulations prescribed by the Secretary. 1. Inclusion in returns. Any person required under the authority of this title to make a return, statement, or other document shall include in such return, statement, or other document such identifying number as may be prescribed for securing proper identification of such person. 2. Furnishing number to other persons. Any person with respect to whom a return, statement, or other document is required under the authority of this title to be made by another person or whose identifying number is required to be shown on a return of another person shall furnish to such other person such identifying number as may be prescribed for securing his proper identification. 3. Furnishing number of another person. Any person required under the authority of this title to make a return, statement, or other document with respect to another person shall request from such other person, and shall include in any such return, statement, or other document, such identifying number as may be prescribed for securing proper identification of such other person. 26 CFR Section 301.6109-1C. If he does not know the taxpayer identifying number of the other person, he shall request such number of the other person. A request should state that the identifying number is required to be furnished under the authority of law. When the person filing the return, statement, or other document does not know the number of the other person, and has complied with the request provision of this paragraph, he shall sign an affidavit on the transmittal document forwarding such returns, statement, or other documents to the Internal Revenue Service, so stating. Until December 1989, 26 U.S.C. Section 6 and 1676 1989 set forth the penalties for failing to supply the Internal Revenue Service with the identifying number. This section states that a $50.00 penalty will be imposed for failure of an employer to provide an identifying number on any document filed with the Internal Revenue Service, unless it is shown that the failure is due to reasonable cause and not willful neglect. The regulation interpreting the statute provides. The Omnibus Budget Restoration Act of 1983 Pub. Law 1-1-239, Title Roman 7, Section 7 and 11b1. Repealed Section 676 of the Internal Revenue Code effective for statements or documents filed after December 31, 1989. Since December 31, 1989, Code Section 6723 has governed the failure to comply with information reporting requirements. Section 6723 provides that a penalty of $50.00 shall be assessed for each failure to comply with a reporting requirement. However, 26 USC Section 6724 provides for a waiver of any penalties assessed under the Code upon a showing of reasonable cause. Section 6724 provides. Therefore, the Code and regulations mandate a payer only to request the identifying number of the employee or payee. If after such a request has been made, the payee does not furnish the payer with his identifying number, the penalty will not be assessed against the payer, upon the filing of an affidavit with the Internal Revenue Service stating that a request for the payee's identifying number was made. Banking as explained above, current federal regulations require financial institution and some other businesses to request Social Security numbers or taxpayer ID numbers from their customers. The law clearly does not require the customer to disclose or provide that information. Furthermore, the law waives penalties if the financial institution shows that absence of the number is due to reasonable cause and not willful neglect. As you review each provision of law where a financial institution is required to request a taxpayer ID number or Social Security number, we find that the law provides for customers who may not have or not wish to disclose such number. 26 CFR Section 301.61 per 9-1C, a payer is required to request the identifying number of the payee. If after such a request has been made, the payee does not furnish the payer with his identifying number, the penalty will not be assessed against the payer. 26 USC Section 6724. No penalty shall be imposed under this part with respect to any failure if it is shown that such failure is due to reasonable cause and not willful neglect. Financial transaction involving currency of more than $10,000. Any financial institution or casino which does a currency transaction of more than $10,000 is expected to obtain the identification of the person making that transaction. 31 CFR Section 103.28 defines that requirement as follows. Note that this regulation does not require a Social Security number. This section simply states that the institution shall verify and record the name and address of the individual presenting a transaction, as well as record the identity, account number, and the Social Security or taxpayer identification number, if any. The term "if any" correctly acknowledges that the person may not have or may not choose to provide a Social Security number. However, if that person does provide a Social Security or taxpayer identification number, then the financial institution is required to record it. Purchase of bank checks or drafts for $3,000 or more. Federal regulations. 31 CFR Section 103.28 requires that no financial institution may issue or sell a check for $3,000 or more, unless it maintains records of the following. 2. If the purchaser does not have a deposit account with the financial institution, i.e. the name and address of the purchaser, b. the Social Security number of the purchaser, or if the purchaser is an alien and does not have a Social Security number, the alien identification number. This regulation seems to imply that a financial institution is prohibited from selling checks to customers without Social Security numbers unless they're aliens. Many financial institutions regard this as their statutory mandate and illegally refuse to sell checks to unenumerated customers. Financial institutions need to read and implement the recording 31 CFR Section 103.28 identification required before concluding any transaction with respect to which a report is required under Sec. 103.22. A financial institution shall verify and record the name and address of the individual presenting a transaction, as well as record the identity, account number, and the Social Security or taxpayer identification number, if any, of any person or entity on whose behalf such transaction is to be effected. Verification of the identity of an individual who indicates that he or she is an alien or is not a resident of the United States must be made by passport, alien identification card, or other official document evidencing nationality or residence, for example, a provincial driver's license with indication of home address. Verification of identity in any other case shall be made by examination of a document, other than a bank signature card, that is normally acceptable within the banking community as a means of identification when cashing checks for non-depositors, for example, a driver's license or credit card. A bank signature card may be relied upon only if it was issued after documents establishing the identity of the individual were examined and notation of the specific information was made on the signature card. In each instance, the specific identifying information, i.e. the account number of the credit card, the driver's license number, etc., used in verifying the identity of the customer shall be recorded on the report, and the mere notation of known customer or bank signature card on file on the report is prohibited. Requirements directed in 31 CFR Section 103.28. As an unenumerated customer, you may need to point this out occasionally. That regulation provides, in part. This regulation is the legal recording requirement that a financial institution must comply with. Note that the financial institution is specifically required to make a notation in the record of the lack thereof if you do not have or provide a taxpayer identification number, Social Security, or employer identification number. Brokerage accounts brokers or dealers are required to ask their customers for Social Security numbers. However, 31 CFR Section 103.35 provides that they are not deemed to be in violation of this section if I. They have made a reasonable effort to secure such identification. For legal protection, brokers and dealers should obtain a signed statement from their unenumerated customers verifying that they requested the number, but were unable to obtain it. Additionally, as an unenumerated customer, you should be willing to offer such a statement. Certificate of deposit accounts. Most banks are very reluctant to open a deposit account for unenumerated customers because they wrongly believe that federal regulations require them to record taxpayer identification numbers for each customer. They often cite 31 CFR Section 103.34 as the mandate requiring them to obtain, thus requiring you to provide a taxpayer identification or Social Security number. The originator's bank shall obtain and retain a record of the name and address, the type of identification reviewed, the number of the identification document, for example driver's license, as well as a record of the person's taxpayer identification number, for example Social Security or employer identification number, or, if none, alien identification number or passport number and country of issuance, or a notation in the record of the lack thereof. 31 CRF Section 103.34 Additional records to be made and retained by banks. 1. With respect to each certificate of deposit sold or redeemed after May 31, 1978, or each deposit or share account opened with a bank after June 30, 1972, a bank shall, within 30 days from the date such a transaction occurs or an account is opened, secure and maintain a record of the taxpayer identification number of the customer involved, or where the account or certificate is in the names of two or more persons, the bank shall secure the taxpayer identification number of a person having a financial interest in the certificate or account. In the event that a bank has been unable to secure, within the 30-day period specified, the required identification, it shall nevertheless not be deemed to be in violation of this section if certainly banks are required to ask their customers for taxpayer identification or Social Security numbers. However, 31 CFR Section 103.34 also provides that the bank is not deemed to be in violation of this section if it has made a reasonable effort to secure such identification. For legal protection, banks should obtain a signed statement from their unenumerated customers verifying that they requested the number, but were unable to obtain it. Additionally, as an unenumerated customer, you should be willing to offer such a statement. Checking accounts. There are no regulatory requirements for obtaining taxpayer identification or Social Security numbers for checking accounts. However, it is reasonable to expect the banks to request a Social Security number or TIN when opening a checking or deposit account. However, there is no requirement for a customer to provide a Social Security number. IAT has made a reasonable effort to secure such identification, and Roman II. It maintains a list containing the names, addresses, and account numbers of those persons from whom it has been unable to secure such identification, and makes the names, addresses, and account numbers of those persons available to the Secretary as directed by him. A bank acting as an agent for another person in the purchase or redemption of a certificate of deposit issued by another bank is responsible for obtaining and recording the required taxpayer identification, as well as for maintaining the records referred to in paragraphs B11 and 12 of this section. The issuing bank can satisfy the record-keeping requirement by recording the name and address of the agent together with a description of the instrument and the date of the transaction. Where a person is a non-resident alien, the bank shall also record the person's passport number or a description of some other government document used to verify his identity. Proof of reasonable effort to secure identifying numbers. It is prudent that every business develop proof that it complied with various requirements to ask customers for, and was unable to obtain, a Social Security number. The following form or similar should be used with those customers for their signature. Opening an account. Nearly any bank will allow customers to open the so-called no/low-interest Christmas accounts that are used for saving small sums of money for Christmas shopping or some other special day. Additionally, parents or children can open a child savings account or college fund account without providing Social Security numbers. While these accounts have their purposes, they are not primarily the kinds of accounts that most unenumerated people want to open. Many of us also have serious banking needs just like other people in our American society. However, one of the problems is that the banking industry has joined, in a way, with the government in attempting to force people into Form P-1 reasonable cause affidavit by a payer for not obtaining pay's identifying number release from Penalty 26 U.S.C. Section 6724. Employer/payer's name and address, employer identification number, employer/payer statement. I, being an officer of, hereby state that I have asked for the identifying number of the employee/payee, who has declined to provide an identifying number. I am filing this affidavit in accordance with 26 U.S.C. 6724, waiver of penalty 26 U.S.C. 6724 assessed under the code upon a showing of reasonable cause, and Treasury Regulation 301.6109-1C. I certify that the information stated here is correct and that I asked the employee/payee for a taxpayer ID number, social security number, and that the employee/payee declined to provide such number. Employer/payer signature date, employee/payee information type or print, employee/payee first name and initial last name, social security number, write none if you do not have a SSN or declined if you do not wish to provide a SSN. Home address number and street or rural road, employee/payee statement. I have declined to provide an identifying number to my employer/payer. City or town, state, and ZIP code. I certify that the information stated here is correct and the employer/payer did ask me for a taxpayer ID number, social security number, and that I declined to provide such number. Employee/payee signature date 26 U.S.C. Section 6724, waiver of penalty 26 U.S.C. Section 6724 assessed under the code upon a showing of reasonable cause, and Treasury Regulation 301.6109-1C. Treasury Regulation 301.6109-1C provides, when the person filing the return statement or other document does not know the SSN of the other person and has complied with the request provision of this paragraph, he shall sign an affidavit on the transmittal document forwarding such returns, statements, or other documents to the Internal Revenue Service, so stating. A payer is required to request the identifying number of the payee. If after such request has been made, the payee does not furnish the payer with an identifying number, the penalty $50 points a year will not be assessed against the payer if it is shown that such failure is due to reasonable cause and not willful neglect. See also 26 U.S.C. Section 6724, waiver of penalty 26 U.S.C. Section 6724 assessed under the code upon a showing of reasonable cause. Public Domain Privacy Form P-102-1999, Cynthia Lewis, Wells Fargo Bank, 512 Broadway, King City, CA 93, 930 George Williamson 487,230,137 George Williamson 8 and 12 North 3rd Street, San Ardo, Calif. Wells Fargo Bank, George Williamson, none. Cynthia Lewis, George Williamson, Cynthia Lewis, Sept. 18, 1999 George Williamson 9/28/99. Enumeration. You are going to find that it is difficult to open an account without a social security number or TIN. Difficult, but not impossible if you are persistent. Many people take the hard-nosed approach of trying to force a bank into opening an account without a social security number. They go into the bank, fill out the application, leave the social security number field blank or write none in the space, and then get angry when the application is rejected. They do all of this without ever having a constructive conversation with the bank manager first. Usually this rejection is not primarily because they didn't provide a social security number, but instead because the bank interpreted them as a security risk. Banks do have a real concern about security and the trustworthiness of their customers, and you should respect that concern since they will soon be holding your money in trust. Obviously, it would be tragic if they were to give your money to somebody who was impersonating you. The nice guy approach. There are primarily two reasons for beginning with this approach. First, it occasionally does work, thus eliminating the need for other action, and you need to establish some degree of trustworthiness anyway. Secondly, the bank or its manager is more likely to provide you with the evidence that you will need should you decide to challenge them more seriously. If your banking needs are not great, for example you only need an account so you can cash checks without incurring a check cashing charge, or you want to open a secured credit card or debit card account, then you might simply visit the bank and talk with the branch manager. Before filling out any paperwork, simply explain to the person that you do not have a social security number and would like to open an account that covers your simple needs, and would like their advice on how the bank might help you. This direct, honest approach will often yield an account that fills your need. If you need an account because you have a lot of money, don't worry about it. The bank will do everything in its power, even waiving its policy, to attract your business. Such accounts usually involve a balance of $15,000 or more, and the more the better. This is particularly true if you are an established business person in your community. The opening an account problems normally occur with the average person who deposits his paycheck and uses a checking account to pay bills and do shopping. Banks and other financial institutions are creatures of habit, and the habit for determining trustworthiness is doing a credit check using your name and social security number. The absence of a credit report, combined with the absence of a social security number, is a red flag to most bankers, and they simply choose to avoid you because they think there is something seriously wrong. A social security number is not necessary for a good credit history report from the major credit reporting companies. If you are unenumerated or you've been resisting disclosure of a social security number, you may have a credit history file that does not include a social security number. Letting the banker know that will go well in your favor. Establishing trust with a banker when you have no social security number and no credit history will be difficult. The first problem that bankers have is that they normally don't believe you when you say you have no social security number. That initial doubt is quickly overcome if you have a credit history that does not include a social security number. In the absence of a credit history, you will need to talk to the manager or operations manager about establishing trustworthiness in some other way. Showing trustworthiness is one key to opening the account you need. If your application for an account is rejected, it most likely will be. It is important that you remain polite and wishful. Your niceness remains important because we need the bank to document the reason they rejected your application. Therefore, you need to follow up with a letter to the branch manager so that the bank will state their reason for rejecting your applications. You may use the sample letter first response to account rejection on page 237. Note, it is important that you do not include your telephone number on any letters. This prevents them from calling you and forces them to write any reply. The bank's branch manager should reply to your letter by listing the items you need to correct in order to open the account. Additionally, they should expand upon their reason for demanding a social security number. Usually they will include something such as the following. Get a little tougher in this phase. We will challenge the financial institution's reason for denying you an account. Generally, their reason relies upon one of the following assertions. Law. The financial institution will state that federal law requires customers doing business with them to disclose a social security number. Policy. The financial institution will state that it is their policy to require all customers doing business with them to disclose a social security number. Sometimes their reason will combine both the policy and legal statement. Their reason for rejecting our application determines what we say next. If it is simply "it's our policy" kind of rejection, then we challenge them with the Privacy Act. However, if they base their rejection on law, then we will also do a Privacy Act challenge, and we will add an under color of law violation warning. Challenging their assertion of law, attempting to trick or intimidate somebody into doing what you wish by telling them that it is the law, when it is not the law, is a felony. It is legal to tell someone to do something without reason, but is illegal to tell somebody that they must do something because a non-existent law requires them to do it. For example, I can legally say to you, you must get a social security number. But I cannot legally say to you, you must get a social security number. It's the law and you will go to jail if you don't get one. In the first example, I simply told you, without giving any reason, to get a number. However, in the second example, I attempted to intimidate you into getting a number by lying about the law. Federal law makes it a crime to trick you under color of law into doing something that you are not required to do. Federal regulations require that we obtain a social security number or tax identification number for many types of accounts, such as bank deposit accounts that pay interest. 18 U.S.C. Section 245 provides criminal penalties for prohibiting a person, under color of law, from freely enjoying the benefits of being a citizen. 18 U.S.C. Section 242 provides criminal penalties for prohibiting a person, under color of law, from freely enjoying the benefits of being a citizen because of the race or religious beliefs. This is important because many people's objection to a social security number is based on their religious belief that it is a type of mark. 42 U.S.C. Section 1983 provides civil penalties for prohibiting a person, under color of law, from freely enjoying the benefits of being a citizen. It should be clearly obvious that it is not only against the law to use the color of law when attempting to get people to do what you want, but it is also foolish since it could result in serious fines and imprisonment. Most bank managers are reasonably aware that 31 CFR Section 103.34 requires them to request a social security number from customers. However, few of them are aware that the same law does not require a customer to provide the number, and that the law actually provides for the likelihood that many customers will not give them the number they request. It is legally proper for a financial institution to say I am required by law to ask you for a social security number. It is asserting illegally, under the color of law, to say the law requires you to provide a social security number. 18 USC Section 245. Federally protected activities be whoever, whether or not acting under color of law, by force or threat of force willfully injures, intimidates or interferes with, or attempts to injure, intimidate or interfere with any person because he is or has been, or in order to intimidate such person or any other person or any class of persons from participating in or enjoying any benefit, service, privilege, program, facility, or activity provided or administered by the United States, c. applying for or enjoying employment, or any perquisite thereof, by any agency of the United States, f. enjoying the goods, services, facilities, privileges, advantages, or accommodations shall be fined under this title, or imprisoned not more than 1 year, or both. 18 USC Section 242. Deprivation of rights under color of law. Whoever, under color of any law, statute, ordinance, regulation, or custom, willfully subjects any person in any state, territory, commonwealth, possession, or district to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States, or to different punishments, pains, or penalties on account of such person being an alien, or by reason of his color or race, than are prescribed for the punishment of citizens, shall be fined under this title or imprisoned not more than 1 year, or both. 42 U.S.C. Section 1983. Civil action for deprivation of rights. Every person who, under color of any statute, ordinance, regulation, custom, or usage of any state or territory or the District of Columbia, subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws shall be liable to the party injured in an action at law, suit in equity, or other proper proceeding for redress. When a financial institution rejects our application for an account based upon the incorrect idea that the law requires us to give them a social security number, then they may be attempting to intimidate us under the color of law into giving them what the law does not actually require. When this happens, we need to send them a letter similar to the second response, compliance with law, on page 239, and attach a copy of the following notice. Since the general concept of American law allows for people to occasionally make mistakes, this letter and notice advises people of the possible violation. They can now offer to correct the violation by allowing you the account you seek, or they can stand fast, now knowing that they are acting in violation of law. Include with this letter the copies of the 2 notices shown under challenging their policy, as follows. Form COL Violation Warning. Denial of rights under color of law. Violation Warning. 18 U.S.C. Section 242. 18 U.S.C. Section 245. 42 U.S.C. Section 1983. Name and address of citizen. Name and address of notice recipient. Citizen's statement. I certify that the foregoing information stated here is true and correct. Citizen's signature. Date. Legal notice and warning. Federal law provides that it is a crime to violate the rights of a citizen under the color of law. You can be arrested for this crime, and you can also be held personally liable for civil damages. Attempting to cause a person to do something by telling that person that such action is required by law, when it is not required by law, may be a felony. 18 U.S.C. Section 242 provides that whoever, under color of any law, statute, ordinance, regulation, or custom, willfully subjects any person in any state, territory, commonwealth, possession, or district to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States, shall be fined under this title or imprisoned not more than 1 year, or both. 18 U.S.C. Section 245 provided that whoever, whether or not acting under color of law, intimidates or interferes with any person from participating in or enjoying any benefit, service, privilege, program, facility, or activity provided or administered by the United States, or applying for or enjoying employment, or any perquisite thereof, by any agency of the United States, shall be fined under this title, or imprisoned not more than 1 year, or both. 42 U.S.C. Section 1983 provides that every person who, under color of any statute, ordinance, regulation, custom, or usage of any state or territory where the District of Columbia subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws, shall be liable to the party injured in an action at law, suit in equity, or other proper proceeding for redress. Warning: you may be in violation of federal law, and persisting with your demand may lead to your arrest and or civil damages. Also understand that the law provides that you can be held personally responsible and liable, as well as your company or agency. You are advised to cease and desist with your demand and to seek personal legal counsel if you do not understand the law. Notice of service. I certify that I personally delivered this notice to above-named recipient and address on it. Public Domain Privacy Form COL01. Mary Coppersmith, 37 Cypress Carmel, Calif. Bank of America 85 Carmel Valley Road, Carmel Valley, CA 93-1923 Wendy Seaman Mary Coppersmith 9/24/99 11:06 a.m. Recipient Wendy Seaman demanded I provide a social security number before providing service. Wendy stated that it was required by law. Mary Coppersmith 9/24/99. Challenging their policy of financial institution, or any business for that matter, cannot implement or enforce policy that is contrary to law. They also cannot enforce policy based on the pretense of law, when there is no such law. For example, attempting to enforce a policy that requires customers to disclose a social security number because of the mistaken belief that everybody has or is required to have a social security number is contrary to the law. Such policy is based on the pretense of law, because there is no law requiring a customer to have a social security number in the first place. Therefore, we need to challenge the financial institution's policy against having unenumerated customers. Use the second response, Privacy Act Notice Letter on page 238 as a model and attach a copy of the following constructive notice and a copy of the citizen's assertion of legal right to withhold disclosure of SSN. This serves to notify the financial institution that their policy violates the law and it violates your rights. These will normally be passed along to their legal department very quickly and will usually result in a letter to you. Since their other option was to ignore you, such a letter, no matter how arrogant, is a positive indication that the legal department wants to negotiate. If you take the simple approach of I understand and appreciate your concern, but I need to establish an account and I would really like to do that with your bank, what must we do to accomplish this? You will usually find them ready to make an offer. It probably won't be the account you envisioned, but it will be an opening in the door that, in time, will allow you to open the account that you actually want. Be reasonable, persistent and patient, and you will succeed. Serving constructive notice. The constructive notice serves to advise the financial institution that you are aware of your rights and that you are preparing to assert them. The notice also advises the financial institution that an alternative does exist. Constructive notice 2. Person being served. Date of name and address of institution. This instrument serves notice to the person and or business, agency, corporation or other entity that the below-named citizen does not have and or refuses to disclose a social security number. This right is protected under the 1st, 4th, 5th, 9th, and 10th Amendments to United States Constitution and provisions of the Privacy Act. The Privacy Act makes it unlawful to require an individual to disclose or furnish a social security number for any purpose, unless the disclosure or furnishing of the number is specifically required by law. The federal courts have ruled that private sector solicitors may not obtain social security numbers until they comport their solicitations to comply with disclosure requirements of the Privacy Act, including informing customers of the voluntary nature of such disclosure, the source of authority for requesting such disclosure, and possible uses to which disclosed numbers might be put. Yeager v. Hackensack Water Co. 615 F.Sup. 1087 1985. Any person who is found violating the rights of a citizen may be subject to the damages sustained by the individual and the costs of the action together with attorney fees. See Doyle v. Wilson, 529 F.Sup. 1343 1982. Violation of 18 U.S.C. Section 241, 242, 42 USC Section 1983, 1985, 1986 shall subject you personally and may also subject you to fines of up to $10,000 and imprisonment for up to 10 years, or both. Federal regulations provide you an alternative. 26 CFR Section 31.6011, 301.6109 and 31 CFR Section 103.28, 103.34, 103.35 employers, banks and payers are required to ask for the Social Security number, but they shall not be in violation of this requirement if they have made a reasonable effort to secure such identification and are unable to secure the information. Your policy must comply with the law and cannot violate the law or the rights of citizens. Compliance with the law and this citizen's intent, as expressly evidenced and implied by this document, is demanded. Non-compliance with this notice and demand shall result in the filing of a formal complaint with the appropriate state and federal agencies against the above named and/or representative S. Constructive notice issued by representing witness. Date Public Domain Form Z02 1999 Bank of America A Fina Carmel Valley Row Carmel Valley C 93 3923 Windy Seaman 924/99 Mary Coppersmith Self-dated Joan the 924/99 Mary Coppersmith dated Jones. Serving citizens assertion of legal right. The citizen's assertion of legal right to withhold disclosure of SSN serves to advise the financial institution that you are aware of your rights and that you are preparing to assert them. Getting tough. If after doing what was suggested in Get a Little Tougher the financial institution still refuses to open the account you requested, you will need to get tough with them. Getting tough means that you are going to do one or both of the following. Form SSN Citizens Assertion of Legal Right to Withhold Disclosure of SSN Public Law 93-579 Section 7. Name and address of citizen. Name and address of notice recipient. Citizen's statement. I certify that the foregoing information stated here is true and correct. Citizen's signature. Date legal notice and warning. Federal law provides that it is a crime to violate the rights of a citizen under the color of law. You can be arrested for this crime and can also be held personally liable for civil damages. Federal law, Section 7 of Public Law 93-579 provides that it shall be unlawful for any federal, state or local government agency to deny to any individual any right, benefit, or privilege provided by law because of such individual's refusal to disclose his Social Security account number. Federal courts have ruled the Privacy Act applies equally to the private sector. Warning: you are in violation of federal law and persisting with your demand may lead to your arrest and/or civil damages. The law provides that you can be held personally responsible and liable, as well as your company or agency. There is no law requiring an individual to obtain or use a Social Security number. Your requirement and/or demand that I provide a Social Security number to you is a violation of one or more of the following laws: 4 CFR 83.9, 5 USC 552A, 7 CFR 1.123, 7 USC 2204G, 14 CFR 1212.604, 17 CFR 249.501A, 19 CFR 118.11, 19 CFR 122.25, 19 CFR 24.5, 24 CFR 5.212, 28 CFR 16.53, 28 CFR 513.31, 28 CFR 700.25, 29 CFR 78.10, 29 CFR 71.12, 31 CFR 1.32, 31 CFR 501.806, 32 CFR 270.19, 32 CFR 310.20, 32 CFR 311.5, 32 CFR 316.6, 32 CFR 317.20, 32 CFR 323.5, 32 CFR 505.2, 32 CFR 701.108, 32 CFR 806b.9, 38 CFR 1.575, 38 CFR 3.216, 38 USC 5101, 39 CFR 266.4, 45 CFR Part 801, 47 CFR 0.554, 49 CFR 10.29. You are advised to cease and desist with your demand and to seek personal legal counsel if you do not understand the law. Notice of service. I certify that I personally delivered this notice to above-named recipient and address on it. 42 USC 408 provides that whoever 8 discloses, uses, or compels the disclosure of the Social Security number of any person in violation of the laws of the United States shall be guilty of a felony and upon conviction thereof shall be fined under Title 18 or imprisoned for not more than 5 years, or both. 18 U.S.C. Section 242 and 42 U.S.C. Section 1983 provides that whoever, under color of any law, statute, ordinance, regulation, or custom, willfully subjects any person in any state, territory, or district to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States, shall be fined under this title or imprisoned not more than 1 year, or both. 42 U.S.C. Section 1983 further provides that a violator shall be liable to the party injured in an action at law, suit in equity, or other proper proceeding for redress. Public Domain Privacy Form SSN 02-2000 Mary Coppersmith 37 Cypress Carmel, Calif. Bank of America 85 Carmel Valley Road Carmel Valley, CA 93 1923 Windy Seaman Recipient Windy Seaman demanded I provide a Social Security number before providing service. Windy stated that it was required by law. Mary Coppersmith 9/24/99/11/6 a.m. Mary Coppersmith Sept. 24, 1999. Sue them under the provisions of 42 U.S.C. Section 1983, which provides civil penalties for prohibiting a person, under color of law, from freely enjoying the benefits of being a citizen. Attempt to have them prosecuted under 18 U.S.C. Section 242, 245, which provides criminal penalties for prohibiting a person, under color of law, from freely enjoying the benefits of being a citizen. Either way, you will need to have your evidence very well documented. The financial institution can bring huge legal resources to its defense and is likely to win simply because of its legal bulk. However, if your case is well documented and your evidence is overwhelmingly in your favor, they will seriously consider an out-of-court settlement. Since our goal has always been to open an account, this now becomes a very reasonable and cost-effective settlement choice for the financial institution. Be sure to have the settlement contract written by an attorney so that it assures establishment of this account. Local credit unions operate along the idea of a co-op. That is, they serve a certain kind of membership. Each credit union has a membership criteria that each person must meet before they can join. Among these are regional credit unions that serve a community, such as a county or city. The membership requirement for these credit unions is that you are a resident of the community. They cannot, and normally will not, attempt to reject your enrollment since you meet the membership requirement by living in the community. They will ask you for a Social Security number, but they cannot reject your application simply because of your failure to provide one unless they have written that as a requirement into their charter. Few credit unions write that requirement into their charter, because they mistakenly assume that everybody has a Social Security number. Local credit unions can provide an excellent alternative for your banking needs. Check cashing. Many financial institutions require people who are cashing checks to have an account with them or to pay a fee for that service. The best way to avoid the service charge is to cash the check at a bank upon which the check is drawn. A check is an order to the bank, by the account holder, to pay this amount of money out of their account on demand of the check. That is, if you present the check to the bank that holds the account, they must pay the face amount of the check, without any service charges. Of course, this assumes that the person who wrote the check has a real account there and funds to cover the check. Unenumerated citizens who do not have a bank account and do wish to assert themselves aggressively can still cash checks free of service fees by going to the bank or any of its branches listed on the check. Credit. Establishing credit without a social security number is much like opening a bank account without a social security number. Understand that the issue is initially not your lack of a social security number, but rather the lack of established trustworthiness. There are many companies who want to lend you money, but only if they believe that they will get their money, plus interest returned in the manner agreed to. If you can prove that they will get their money back or provide some valuable collateral, then you will find somebody who will provide you the credit you need. The key to obtaining credit is having a good credit history file with the major credit reporting companies. The credit reporting companies do not care whether or not you have a social security number. They simply record the information that you provide them along with the information that lenders give them. That is all they do. You can establish a credit history file without a social security number, and having a good credit history file is key to obtaining future credit and to banking. The easiest places where you can establish new credit is with used car dealers and overpriced layaway jewelry stores. However, if you live in a smaller community or have an established business in your community, you can normally work with another local business to help you establish the credit report you need. Remember that your initial concern should not be with gaining credit for credit's sake, but getting credit for the purpose of establishing a credit history file that does not contain a social security number. See credit reporting agencies on page 92 for more information about credit reports. 61. Dealing with federal agencies. Most federal agencies ask people for a social security number, but do not actually require an identity number from people. There is usually no issue involved when a person declines to provide a social security number to federal agencies. However, there are a few hard requirements for a social security number that are very difficult, if not impossible, to defeat. For example, the most obvious is that a person cannot receive social security benefits without obtaining and using a social security number. Here are a few other examples. Section 8: Housing Assistance, Food Stamps, Government Guaranteed Loans, Student Loans, Federal Crop Insurance. But even this requirement is not always true because the court has, on occasion, defended an individual's religious right against enumeration. For example, in Bowen v. Roy, 476 U.S. 1693-1986, the court ruled that the public interest in maintaining an efficient and fraud-resistant system could be met without requiring a social security number for the child. The court then enjoined the Secretary of Health and Human Services from using and disseminating the social security number issued in the child's name, and also enjoined the federal and state defendants from denying appellees benefits. Selective service registration is defined in 50 U.S.C. Section 453. As shown below, Section B directs the registrant to provide such identifying information including date of birth, address, and social security account number as such regulations may prescribe. Bowen v. Roy, 476 U.S. 1693-1986, appellees applied for and received benefits under the Aid to Families with Dependent Children (AFDC) program and the Food Stamp program. They refused, however, to comply with the federal statutory requirements that participants in those programs furnish the state welfare agencies who administer the programs with their social security numbers and those of each member of their household as a condition of receiving benefits, and that each state agency utilize those numbers in administering the programs. Appellees contended that obtaining a social security number for their 2-year-old daughter would violate their Native American religious beliefs. Thereafter, the Pennsylvania Department of Public Welfare terminated AFDC benefits payable to appellees on the child's behalf and instituted proceedings to reduce the level of food stamps that appellees' household was receiving. Appellees then filed an action in federal district court, claiming that the Free Exercise Clause of the First Amendment entitled them to an exemption from the Social Security number requirements, and requesting injunctive and other relief. Following a trial in which it was disclosed that the child had in fact been assigned a Social Security number, the court held that the public interest in maintaining an efficient and fraud-resistant system could be met without requiring a Social Security number for the child. The court then enjoined the Secretary of Health and Human Services from using and disseminating the Social Security number issued in the child's name, and also enjoined the federal and state defendants from denying appellees benefits until the child's 16th birthday because of their refusal to provide a Social Security number for her. 50 USC Section 453. Registration except as otherwise provided in this title sections 451 to 471A of this appendix. It shall be the duty of every male citizen of the United States, and every other male person residing in the United States, who, on the day or days fixed for the first or any subsequent registration, is between the ages of 18 and 26, to present himself for and submit to registration at such time or times and place or places, and in such manner, as shall be determined by proclamation of the President and by rules and regulations prescribed hereunder. The provisions of this section shall not be applicable to any alien lawfully admitted to the United States as a non-immigrant under Section 101 of 15 of the Immigration and Nationality Act, as amended 66 Stat. 163, 8 U.S.C. 1101, for so long as he continues to maintain a lawful non-immigrant status in the United States. B. Regulations prescribed pursuant to subsection A may require that persons presenting themselves for and submitting to registration under this section provide, as part of such registration, such identifying information including date of birth, address, and Social Security account number as such regulations may prescribe. Dealing with federal agencies 63. The appropriate regulations for this section are 32 CFR Section 1615.4 and 32 CFR Section 1615.6. Registering without a Social Security number. The instruction accompanying Selective Service System registration form states that if you have a Social Security account number, it is mandatory that you include this information. Leave item 3 blank if you do not have a Social Security number or if do not wish to provide a Social Security number. Military service. Most people know that all branches of the United States military and National Guard use the Social Security number as the military service number. What few people realize is that 32 CFR Section 1615.4 duty of persons required to register. A person required by Selective Service law to register has the duty to complete the registration card prescribed by the Director of Selective Service and to record thereon his name, date of birth, sex, Social Security account number (SN), current mailing address, permanent residence, telephone number, date signed, and signature, and B. to submit for inspection evidence of his identity at the time he submits his completed registration card to a person authorized to accept it. Evidence of identity may be a birth certificate, motor vehicle operator's license, student's identification card, United States passport, or a similar document. 32 CFR Section 1615.6 Selective Service Number. Every registrant shall be given a Selective Service Number. The Social Security account number will not be used for this purpose. Federal regulations protect recruits and members of the military from divulging a Social Security number if they choose to keep it private. Executive Order 9397, Numbering System for Federal Accounts Relating to Individual Persons, provides that if the individual refuses to disclose his or her Social Security number, the military activity must be prepared to identify the individual by alternate means. This is codified in Regulations 32 CFR Section 310.20, 32 CFR Section 505.4, and 32 CFR Section 806B.9. Prohibited from requiring a Social Security number when you join the military service. If you do not have a Social Security number or choose not provide a Social Security number, the military will simply assign you a service number that looks like a Social Security number. 32 CFR Section 310.20, B. Collecting Social Security Numbers SSNS. 1. It is unlawful for any federal, state, or local governmental agency to deny an individual any right, benefit, or privilege provided by law because the individual refuses to provide his or her SSN. However, if a federal statute requires that the SSN, for Executive Order 9397, Numbering System for Federal Accounts Relating to Individual Persons, November 30, 1943, authorizes solicitation and use of SSNs as numerical identifier for individuals in most federal records systems. However, it does not provide mandatory authority for soliciting SSNs. 5. Upon entrance into military service or civilian employment with the Department of Defense, individuals are asked to provide their SSNs. The SSN becomes the service or employment number for the individual and is used to establish personnel, financial, medical, and other official records. Provide the notification in paragraph B2 of this section to the individual when originally soliciting his or her SSN. After an individual has provided his or her SSN for the purpose of establishing a record, the notification in paragraph B2 is not required. 32 CFR Section 505.4. See Social Security Number SSN. Executive Order 9397 authorizes the Department of the Army to use the SSN as a system of identifying Army members and employees. Once a military member or civilian employee of the Department of the Army has disclosed his or her SSN for purposes of establishing personnel, financial, or medical records upon entry into Army service or employment, the SSN becomes his or her identification number. No other use of this number is authorized. Therefore, whether the SSN alone is requested from the individual, or the SSN together with other personal information, the Privacy Act statement must make clear that disclosure of the number is voluntary. If the individual refuses to disclose his or her SSN, the Army activity must be prepared to identify the individual by alternate means. 32 CFR Section 806b.9. Do not deny people a legal right, benefit, or privilege for refusing to give their SSNs unless. See Executive Order 9397, November 22, 1943, authorizes using the SSN as a personal identifier. This order is not adequate authority to collect an SSN to create a record. When law does not require disclosing the SSN or when the system of records was created after January 1, 1975, you may ask for the SSN, but the individual does not have to disclose it. If the individual refuses to respond, use alternative means of identifying records. Passport. A passport is obtained by completing a United States Department of State Form DSB-11, application for passport/registration and paying a fee. The form is available through most United States post offices. Item 6 on the form asks for a Social Security number and refers you to a note on page 2 of the application. The instructions provide that if you have not been issued a Social Security number, you should enter zeros in the box. Enter zeros or leave it blank. A Social Security number is not needed for obtaining a passport. The Item 6 box is included on the application to comply with the Internal Revenue Service requirement to collect taxpayer identification numbers 26 U.S.C. Section 6039E. Assuming all other requirements are met, the Department of State will give you a passport even if you leave this box blank. 26 USC Section 6039E. Information concerning resident status. A general rule notwithstanding any other provision of law, any individual who 1 applies for United States passport or renewal thereof, or 2 applies to be lawfully accorded the privilege of residing permanently in the United States as an immigrant in accordance with the immigration laws, shall include with any such application a statement which includes the information described in subsection B. B. Information to be provided. Information required under subsection A shall include 1. The taxpayer's TAN if any, 2. In the case of a passport applicant, any foreign country in which such individual is residing, 3. In the case of an individual seeking permanent residence, information with respect to whether such individual is required to file a return of the tax imposed by Chapter 1 for such individual's most recent 3 taxable years, and for such other information as the Secretary may prescribe. See penalty. Any individual failing to provide a statement required under subsection A shall be subject to a penalty equal to $500 for each such failure, unless it is shown that such failure is due to reasonable cause and not to willful neglect. D. Information to be provided to Secretary notwithstanding any other provision of law, any agency of the United States which collects or is required to collect the statement under subsection A shall 1. Provide any such statement to the Secretary, and 2. Provide to the Secretary the name and any other identifying information of any individual refusing to comply with the provisions of subsection A. The law provides for a $500.00 penalty if you fail to answer this information correctly. However, according to United States General Accounting Office Report GGD 98-196, non-filing among U.S. citizens abroad, May 1998, this is never enforced. On page 3, we read the following. Although the Internal Revenue Service is not currently using this data, be aware that they could begin any time. Also understand that there is no penalty if a Social Security number has nothing in a preceding sentence shall be construed to require the disclosure of information which is subject to Section 245A of the Immigration and Nationality Act as in effect on the date of the enactment of this sentence. Exemption: the Secretary may by regulations exempt any class of individuals from the requirements of this section if he determines that applying this section to such individuals is not necessary to carry out the purposes of this section. First, although IRS obtains passport data from the State Department, it has made little use of this data, and in recent years, IRS has not attempted to penalize the large number of applicants who failed to furnish an SSN, as the law provides. Not been issued. The Internal Revenue Service has the burden of proof to show that a Social Security number has been issued. Internal Revenue Service: the best-kept secret in America is that the Internal Revenue Service never contacts or issues correspondence regarding income tax to citizens who do not have, or use, a Social Security number. Certainly it is more difficult for the IRS and other government agencies to track people who have no Social Security number, which is why they push so hard to get everybody enumerated. Of course, every American who owes income tax should pay what they owe, whether they're enumerated or not. Since unenumerated people pay exactly what they owe, they are more responsible and honest than government agencies that perpetuate the fraud, or the people who acquiesce in ignorance. Any person who does not have a Social Security number may still pay any income they wish or any income tax that they owe. The 31% withholding myth: most people, businesses, and banks have been told that they must withhold 31% of a payment from a person who does not provide their Social Security number. Most people, when threatened with a 31% withholding from their pay, quickly give in to the demand that they must provide a Social Security number. The threat of the 31% assessment is based upon the reading of 26 U.S.C. Section 3406. Omission of isolated information not seriously hampering the IRS's ability to check a taxpayer's asserted tax liability. For example, the omission of a taxpayer's Social Security number or the non-disclosure of the names of one's dependent children does not invalidate a return under Section 7203. United States v. Grabinski, 727 F.2d 681, 686, A78 Sir. 1984. 26 USC Section 3046. Backup: withholding: a requirement to deduct and withhold one in general in the case of any reportable payment. If the payee fails to furnish his TN to the payer in the manner required, b. the Secretary notifies the payer that the TN furnished by the payee is incorrect. C. there has been a notified payee under reporting described in subsection C. Or d. there has been a payee certification failure described in subsection D. Then the payer shall deduct and withhold from such payment a tax equal to 31% of such payment. 2. Subparagraphs C and D of paragraph 1 apply only to interest and dividend payments. Subparagraphs C and D of paragraph 1 shall apply only to reportable interest or dividend payments. When you consider that TIN means taxpayer identification number and that another section of law defines the TIN as also meaning an individual's Social Security number, then a quick reading of this section certainly appears to mandate the 31% withholding from two categories: a reportable interest or dividend payment, and b. any other reportable payment. We don't need to review the sections of law defining reportable interest or dividend payment because that section pretty much defines what most of us expect interest and dividend payments to be. Interest from a bank savings account, for example, is the money that the bank pays you for letting them use your money. The interest is calculated based upon the principal amount of money you have deposited with them. This law withholds 31% of the interest and does not harm the principal. For example, if you deposit $1,000 via in a simple interest-bearing account that pays you 5% interest, the bank would pay $50 via. If you do not give them a TIN, they will withhold $15.5 31% of $50 via from the interest payment, the b. reportable payment, etc. For purposes of this Section 1 reportable payment, the term reportable payment means any reportable interest or dividend payment, and b. any other reportable payment. 2. Reportable interest or dividend payment. In general, the term reportable interest or dividend payment means any payment of a kind, and to a payee, required to be shown on a return required under I Section 6049 relating to payments of interest, Roman 2 Section 6042 relating to payments of dividends, or Roman 3 Section 6044 relating to payments of patronage dividends, but only to the extent such payment is in money. B. Special rule for patronage dividends. For purposes of subparagraph C and D of subsection A1, The term reportable interest or dividend payment shall not include any payment to which Section 6044 relating to patronage dividends applies unless 50% or more of such payment is in money. 3. Other reportable payment. The term other reportable payment means any payment of a kind, and to a payee, required to be shown on a return required under Section 6041 relating to certain information at source. B. Section 6041A relating to payments of remuneration for services. C. Section 6045 relating to returns of brokers. D. Section 6050A relating to reporting requirements of certain fishing boat operators, but only to the extent such payment is in money and represents a share of the proceeds of the catch. Or E. Section 6050N relating to payments of royalties. Withholding has the same effect as paying you only 3.45% interest on your account rather than 5%. Some people find the privacy gained from the lower interest account worth the cost. Regardless of how the banker words the threat to withhold 31%, they can only withhold from the interest that they pay you. They cannot touch the principal. Threatening to withholding 31% of reportable income is taken much more seriously when it is 31% of your labor compensation paycheck. However, as with most tax law, this too is not as clear as it first appears. There are several things to consider. First is the issue of reportable payment. Secondly, we need to understand the legal meaning of the word fail. The meaning of reportable payment is given to us in subsection B, but we must look to Black's Law Dictionary for the meaning of fail. Reportable payment specifically. For our understanding of reportable payment, we need to look at subsection 3, other reportable payment. That subsection lists the following references that the law uses to define what this means. Those references are included here with their meaning and your reporting duty. 26 U.S.C. Section 6041 Information at source of payments of $600 or more. See recipient to furnish name and address when necessary to make effective the provision of this section. The name and address of the recipient of income shall be furnished upon demand of the person paying the income. 26 U.S.C. Section 6041A returns regarding payments of remuneration for services and direct sales. F. Recipient to furnish name, address, and identification number. Inclusion on return 1. Any person with respect to whom a return or statement is required under this section to be made by another person shall furnish to such other person his name, address, and identification number at such time and in such manner as the Secretary may prescribe by regulations. 26 U.S.C. Section 6045 Returns of brokers. A general rule: every person doing business as a broker shall be statements to be furnished to customers. Every person required to make a return under subsection A shall furnish to each customer whose name is required to be set forth in such return a written statement showing 1. The name, address, and phone number of the information contact of the person required to make such return, and 2. The information required to be shown on such return with respect to such customer. The reporting duty for each of these sections require you to provide your name and address. Only 26 U.S.C. Section 6041A asks you to provide an identifying number. But from whom is that number expected? There is no expectation for an identifying number from any other section. Be very suspicious anytime the written code becomes ambiguous, and this one is really ambiguous. Let's see if we can figure out what is being said here. Any person who is expected to provide a return by another person shall furnish the other person his name. Shall furnish to such other person, in such manner as the Secretary. Any person to whom a statement is required to be made by another person. Another person shall furnish to such other person. A statement is required to be made by another person. Any person who is expecting a statement from another person shall furnish the other person. Any of the above. Okay, I give up. I think the only thing we can agree on here is that this is truly ambiguous and totally meaningless. We can simply disregard this as any kind of requirement. After reviewing each piece of the code associated with the 31% withholding requirement, it becomes obvious that it applies only to a portion of interest paid, and any other application is simply a myth. When someone threatens to withhold 31% of the amount of money they owe you, be sure to remind them that you expect them to comply with the applicable laws and will seek criminal and civil damages if they violate the law or commit fraud against you. 26 U.S.C. Section 6050A Reporting requirements of certain fishing boat operators or reports. 1. The identity of each individual performing such services. 26 U.S.C. Section 6050 and returns regarding payments of royalties, a requirement of reporting. 2. Setting forth the aggregate amount of such payment and the name and address of the person to whom paid. Any person with respect to whom a return or statement is required under this section to be made by another person shall furnish to such other person his name, address, and identification number at such time and in such manner as the Secretary may prescribe by regulations. Pay fails to furnish. Black's Law Dictionary defines the meaning of the word fail as: certainly, if you have a social security number and you fail to furnish it, then the sentence in subsection A might apply to you. The ownership of his TIN is addressed in whose number is it anyway on page 247, and that issue is also applicable here. The fail issue becomes clearer when we look at the sentence and restructure the various meanings for the word fail. The payee fails to furnish his TIN to the payer in the manner required of the payee, because of his own fault, does not furnish his TIN to the payer in the manner required of the payee, because of his own negligence, does not furnish his TIN to the payer in the manner required of the payee, refuses to furnish his TIN to the payer in the manner required. However, the law does not require you to furnish that which you do not have. The law cannot be interrupted nor can it be twisted to mean. The payee, who does not have or want a TIN, fails to furnish his TIN to the payer in the manner required. The meaning of the word fail requires that you to do one of the following. Fail to furnish a TIN through some fault of your own, such as, you forgot it or forgot to write it on the form. Fail to furnish a TIN through some kind negligence, such as, you forgot to write it on the form or simply don't care. Fail to furnish a TIN because you simply refuse to provide it. It does not include or mean that you fail to furnish a TIN because you do not have one. You would be happy to furnish it if you had one, but you simply don't have one to give them and you have no desire to obtain one. When you understand the legal meaning of the word fail, it becomes clear that this does not apply to people to whom a social security numbers have not been issued and do not wish to obtain one. Fail, fault, negligence, or refusal. Statements required from payer. Federal Regulation 26 CFR Section 31.6051-4 defines the statement and method of reporting that a payer must use when doing a backup withhold under the provisions of 26 U.S.C. Section 3406. Notice the mandatory language in Section C and C1. Here we see the phrase must show. While the courts and the law books play with the meaning of the word shall, there is no such debate regarding the use of the word must. The law mandates that every payer of any reportable payment as defined in Section 3406b1 who is required to deduct and withhold tax under Section 3406 must furnish to the payee a written statement containing information required, and the required information must show the name, address, and taxpayer identification number of the person receiving any reportable payment. If the payer cannot show these three items, they cannot comply with the law and may be penalized for providing a frivolous return if they attempt to do so. 26 CFR Section 31.6051-4 Statement required in case of backup withholding. A statement's required from payer. Every payer of any reportable payment as defined in Section 3406b1 who is required to deduct and withhold tax under Section 3406 must furnish to the payee a written statement containing the information required by paragraph C of the section. B. Prescribed form. The prescribed form for the statement required by this section is Form 199. In the case of any reportable interest or dividend payment as defined in Section 3406b2, the prescribed form is the Form 199 required in Sec. 1.6042-4 of this chapter relating to payments of dividends, Sec. 1.6044-5 of this chapter relating to payments of patronage dividends, or Sec. 1.6049-6e of this chapter relating to payments of interest or original issue discount. Statements required to be furnished by this section will be treated as statements required by the respective sections with respect to any reportable payment, except that the statement required under this section must include the amount of tax withheld under Section 3406. In no event will a statement be required under this section if a statement with the same information is required to be furnished to the recipient under another section. See information required. Each statement on Form 1099 must show the following. 1. The name, address, and taxpayer identification number of the person receiving any reportable payment. to the amounts subject to reporting under Section 6041, 6041A, 6042, 6044, 6045, 6049, 6050A, or 6050N whether or not the amount of the reportable payment is less than the amount for which an information return is required. If tax is withheld under Section 3406, the statement must show the amount of the payment withheld upon 3. The amount of tax deducted and withheld under Section 3406, 4. The name and address of the person filing the form, 5. A legend stating that such amount is being reported to the Internal Revenue Service, and 6. Such other information as is required by the form. D. Time for furnishing statements. The statement must be furnished to the payee no later than January 31 of the year following the calendar year in which the payment was made. E. Aggregation. The payer or broker may combine the information required to be shown under this section with information required to be shown under another section, even if they do not relate to the same type of reportable payment. Social Security Administration. Few people realize that Social Security is a totally voluntary system, and they can avoid it by never obtaining a Social Security number. They can get out of Social Security if they simply stop using a Social Security number. However, the latter is more difficult to accomplish, and the longer you have resided within the system, the longer and more difficult it is to get out of the system. You get into the system by obtaining a Social Security card. You avoid the system by not getting a Social Security card. You sidestep the system by getting your application for a Social Security card rejected. And you get out of the system by not using a Social Security number for at least 10 years. Obtaining a Social Security number. Any lawful resident of the United States may obtain a Social Security number by completing the application for a Social Security card SS5. This application is used by anyone who has never been issued a Social Security card, needs a replacement card, or has changed his or her name. Complete the SS5 using the accompanying instructions. The instructions also list the kind of evidence that you need to submit with your application. Finally, take or mail the SS5 to the nearest Social Security office. The Social Security Administration will return your original documents right away and send you a Social Security card in about 2 weeks. You can get the application for a Social Security card SS5 from any local Social Security Administration office. Getting your application rejected. Many people may wonder why you would want to fill out an application for a Social Security card in the first place, especially if your only intent is to have the application rejected. The reason is that the Social Security Administration has begun issuing a special ineligibility letter SSAL 676 to people who are not eligible for Social Security numbers, and these letters are accepted by the state agencies who issue driver's license as a valid reason for not having a Social Security number. See Get a Letter of Ineligibility from the Social Security Administration on page 82 for more information about getting a driver's license using this letter. You get your application for a Social Security card rejected by completing the application form in such a way that causes the Social Security Administration to believe that you are an illegal alien. You get the rejection letter issued immediately if you submit the application in person at any local Social Security Administration office and they reject the application. You should use your real name so that the letter is addressed to you, but you need to use a different place of birth, mother and father, and addresses from your real ones. They will reject the application because you have none of the required supporting documentation, such as an American birth certificate, ID card, or visa. Social Security regulations require each applicant to provide convincing evidence. The Social Security Administration will not issue a Social Security card if you fail this requirement. The rescinding a Social Security number scam. There is a growing number of Americans who, for various reasons, no longer trust the Social Security system. This growing concern has created a new market among the small group of charlatans who sell various programs telling their customers how they can rescind or void their Social Security number. Many of these groups present very convincing arguments. Regardless of what they claim, save your money. There is no program or method for rescinding a Social Security number once it has been issued. The Social Security Administration is not authorized to rescind an application or void a Social Security number. Getting out of the system. For most people, getting out of the system is the only viable alternative. If you have no government liens filed against you, this process takes about 10 years to complete. If you have government liens, it may take as long as 20 years to complete. Either way, it is a long time, but your part in it is easy, or actually hard, because it simply requires you to do nothing during that time. It takes it long for the Internal Revenue Service and the various credit reporting agencies to simply drop you from their active systems. 20 years if tax liens are involved, because it may take that long for the county agencies who record the lien to consider them stale. Sometimes moving to another county or state will help you lose these liens. Doing nothing in this case means that you cannot use a social security number for anything for 10 years and that you cannot file for any kind of credit. Additionally, you cannot file for bankruptcy or do anything that creates a credit report or a federal tax record. This is difficult, but it can be done, and the system will simply forget that you exist. The advantage of letting the system forget that you exist is that you can still apply for Social Security benefits later in life should you wish to do so. Note that minor police problems should not affect this waiting period. Getting a new number assigned. There are a few good reasons why you might want to get a new Social Security number assigned to you. The reasons usually have to do with personal or financial safety. For example, a battered spouse or seriously threatened person may want to obtain a new number, or someone whose identity has been stolen for the purpose of financial fraud. 20 CFR 422.107 Evidence Requirements. An applicant for an original Social Security number card must submit documentary evidence which the Commissioner of Social Security regards as convincing evidence of age, U.S. citizenship or alien status, and true identity. An applicant for a duplicate or corrected Social Security number card must submit. There are two ways to approach obtaining a new Social Security number. The first, and for many, the easiest way, is to simply fill out and submit a new application using different historical information. These often get rejected because you don't have the necessary support information, but such applications are also successful often enough to make trying it worth considering. The greatest disadvantage is that you give up your past Social Security earnings and credit history. The other way is to ask the Social Security Administration to issue a new number to you because of the problem. The Social Security Administration is very reluctant to issue another number and often do it only after being ordered to do so by a United States District Court or the Social Security Administration's hearing process. However, with sufficient documentation, such as police reports about physical violence or the threat, evidence of financial fraud against you, and other supporting evidence, they will often issue a new number. If the Social Security Administration is reluctant to issue a new number, and you really need to do this, then file a claim in the district court. Check with the court about getting your fees waived and talk to a good paralegal who can draft your request. Even without an attorney, the courts are very good at hearing these issues when your need is legitimate. They nearly always grant your request to order the Social Security Administration to issue a new number. United States Census. The law says you can refuse to give a Social Security number during any census. Violation of the Fifth Amendment. The Fifth Amendment to the Constitution of the United States Constitution prohibits the government from requiring a person to provide any information that could be used against them in court. There are many stipulations within federal law that require various government agencies to share Social Security numbers with law enforcement agencies for the purpose of possibly accusing you of a crime. You should be aware of these requirements, and in many cases you may wish to refuse to provide Social Security number information because the failure or refusal of a person to disclose the person's Social Security number in response to a request made in connection with any census or other activity under this section shall not be a violation. To do so would violate your Fifth Amendment protection. For simplicity, these laws are simply listed. Code Title Purpose 07 U.S.C. Sec. 2020 Agriculture Food Stamp Program Administration. Social Security number shall be made available to law enforcement. 26 USC 6103 Internal Revenue Code Confidentiality and Disclosure of Returns and Return Information. Internal Revenue Service may disclose information from the master files of the Internal Revenue Service relating to the Social Security account number. Disclose to any child support enforcement agency. Address and Social Security account number. 42 USC 1382 Public Health and Welfare eligibility for benefits. The institution shall provide Social Security account numbers. Commissioner shall furnish law enforcement Social Security number. 42 USC 1437Z Public Health and Welfare Exchange of Information with Law Enforcement Agencies. Notwithstanding any other provision of law, each public housing agency that enters into a contract for assistance under Section 1437D or 1437F of this title with the Secretary shall furnish any federal, state, or local law enforcement officer, upon the request of the officer, with the current address, Social Security number. 42 USCSEC 666 Public Health and Welfare Child Support and Establishment of Paternity Requirement of statutorily prescribed procedures to improve effectiveness of child support enforcement in order to satisfy Section 654(20) of this title. Each state must have in effect laws requiring the use of the following procedures, which the state child support enforcement agency shall request. Social Security account number, requiring that the Social Security number at any applicant for license be recorded on the application with financial institutions doing business in the state to provide Social Security number for each non-custodial parent. 12 CFR 21.11 Suspicious Activity Report. A national bank shall file SAR if it is determined prior to filing this report that the identified suspect or group of suspects has used an alias, then information regarding the true identity of the suspect or group of suspects, as well as alias identifiers, such as drivers' license or Social Security numbers, addresses and telephone numbers, must be reported. 12 CFR 208.62 Suspicious Activity Reports. A member bank shall file SAR if it is determined prior to filing this report that the identified suspect or group of suspects has used an alias, then information regarding the true identity of the suspect or group of suspects, as well as alias identifiers, such as drivers' licenses or Social Security numbers, addresses and telephone numbers, must be reported. 12 CFR 353.3 Reports and Records. A bank shall file a suspicious activity report if it is determined prior to filing this report that the identified suspect or group of suspects has used an alias, then information regarding the true identity of the suspect or group of suspects, as well as alias identifiers, such as driver's license or Social Security numbers, addresses, and telephone numbers, must be reported. 12 CFR 563.180 Suspicious Activity Reports and Other Reports and Statements. Savings associations and service corporations file a suspicious activity report if it is determined prior to filing this report that the identified suspect or group of suspects has used an alias, then information regarding the true identity of the suspect or group of suspects, as well as alias identifiers, such as driver's license or Social Security numbers, addresses, and telephone numbers, must be reported. 29 CFR 102.170 Agency Referral to IRS for Tax Referral Effect. Agency responsibilities. As authorized and required by law, the agency may refer past due legally enforceable debts to the Internal Revenue Service. Such referrals shall include the following information: to the name and taxpayer identification number SSN or EIN of the debtor who is responsible for the debt. Code title purpose. 79 Dealing with state and county agencies. Believe it or not, the worst of all bureaucrats to deal with, when withholding a Social Security number, sit in various state and county agencies. Most of these agencies have a total disregard for the law or for your rights. However, the most important thing on our side is the law. Section 7 of Public Law 93-579, as enacted by the Congress of the United States, reads as follows. According to a 2B of this law, a requirement for the disclosure of a Social Security number to any federal, state, or local agency is only lawful if such requirements were in existence and operating before January 1, 1975. Thereby, Congress attempts to prohibit any federal, state, or local agency from adopting laws or regulations after January 1, 1975 that require a Social Security number from people. Ignorance of the law is an excuse for some. There have been several stories about citizens suing bureaucrats personally for violating the Privacy Act and losing because that portion of the law is obscured as a footnote to 5 U.S.C. Section 552A. The bureaucrat pleaded ignorance of the law because the law had not been properly codified, and therefore he could not have known. According to the story, the judge ruled against the plaintiff and in favor of the bureaucrat, agreeing that although ignorance of the law is not a valid defense, this case was different because the law had not been codified. 1. It shall be unlawful for any federal, state, or local government agency to deny to any individual any right, benefit, or privilege provided by law because of such individual's refusal to disclose his Social Security account number. 2. That the provisions of paragraph 1 of this subsection shall not apply with respect to any disclosure which is required by federal statute, or b. the disclosure of a Social Security number to any federal, state, or local agency maintaining a system of records in existence and operating before January 1, 1975, if such disclosure was required under statute or regulation adopted prior to such date to verify the identity of an individual. b. Any federal, state, or local government agency which requests an individual to disclose his Social Security account number shall inform that individual whether that disclosure is mandatory or voluntary, by what statutory or other authority such number is solicited, and what uses will be made of it. We have not been able to find any such court case to substantiate this story. However, with the increasing pressure being directed against citizens, we felt there might be some element of truth to this story. This notification card is designed specifically for the purpose of defeating this supposed ignorance of the law defense. Serving this card on each bureaucrat who gives you grief regarding your rights, advises him of the law, his personal liability under the law, and your right to collect damages from him. Be sure to make a copy and, if possible, get a witness. This card is a very powerful tool in asserting your rights. When completing various government application and forms, leave any space that asks for a Social Security number blank. If they ask for it, tell the person receiving the application that you do not have a Social Security number. Serve a copy of this notice regarding disclosure of Social Security number card on the person who tells you that they cannot process your application. This serves to notify that person that he/she will be held personally and criminally liable for violating the law and for violating your rights. When given this notice, most people will process your application. Driver's license. 2 federal laws, 42 U.S.C. Section 666 and 42 U.S.C. Section 405 have recently been interpreted by the states as their mandate to begin requiring Social Security numbers from driver's license applicants. With blatant disregard for the 9th and 10th Amendments to the United States Constitution and the state's obligation to protect their citizens, each state of the Union has notice regarding disclosure of Social Security number. Section 7 of Public Law 93-579, as enacted by the Congress of the United States, provides that 1. It shall be unlawful for any federal, state, or local government agency to deny to any individual any right, benefit, or privilege provided by law because of such individual's refusal to disclose his Social Security account number. 2. The provisions of paragraph 1 of this subsection shall not apply with respect to any disclosure which is required by federal statute, or b. the disclosure of a Social Security number to any federal, state, or local agency maintaining a system of records in existence and operating before January 1, 1975, if such disclosure was required under statute or regulation adopted prior to such date to verify the identity of an individual. b. Any federal, state, or local government agency which requests an individual to disclose his Social Security account number shall inform that individual whether that disclosure is mandatory or voluntary, by what statutory or other authority such number is solicited, and what uses will be made of it. 18 USC Sec. 242 and 42 U.S.C. Sec. 1983 provides that whoever, under color of any law, statute, ordinance, regulation, or custom, willfully subjects any person in any state, territory, or district to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States, shall be fined under this title or imprisoned not more than 1 year, or both. 42 USC Sec. 1983 further provides that a violator shall be liable to the party injured in an action at law, suit in equity, or other proper proceeding for redress. 42 USC Sec. 408 provides that whoever 8 discloses, uses, or compels the disclosure of the Social Security number of any person in violation of the laws of the United States shall be guilty of a felony and, upon conviction thereof, shall be fined under Title 18 or imprisoned for not more than 5 years, or both. Served on name of person served, An agent or employee of name of business or agency was informed of the law entered date at time and is fully aware of the congressional restriction placed upon him/her and the penalties he/she may suffer for violating the law by requiring me to provide a social security number which I may not have nor am I required to provide, or am providing under duress. Signed, your name and signature witnessed, name and signature Robert Jones Califf. Department of Motor Vehicle 9/20/99 to 30 p.m. Pam Watson Larry Simons. Dealing with state and county agencies, 81 implemented laws making it very difficult, if not impossible, for the unenumerated to obtain a driver's license. 42 U.S.C. Section 666 implemented by Public Law 1/485 become effective on Oct. 1, 1985 and was modified in 1997 by Public Law 1/983 to include all driver's license and recreational license. Only lawful if it was done before January 1, 1975 according to a 2B of Public Law 93-579 the Privacy Act, a requirement for the disclosure of a social security number to any federal, state, or local agency is only lawful if such requirements were in existence and operating before January 1, 1975. Thereby, Congress prohibits any federal, state, or local agency from adopting enforceable laws or regulations after January 1, 1975 that require a social security number from people. When you complete a license application, leave any space that asks for a social security number blank. If the clerk asks for it, tell them that you have no social security number. Serve a copy of the notice regarding disclosure of social security number card shown at the beginning of this section on the clerk if they tell you that they cannot process your license application. This serves to notify the clerk that he/she will be held personally and criminally 42 U.S.C. Section 405C2C. CI It is the policy of the United States that any state or political subdivision thereof may, in the administration of any tax, general public assistance, driver's license, or motor vehicle registration law within its jurisdiction, utilize the Social Security account number issued by the Commissioner of Social Security for the purpose of establishing the identification of individuals affected by such law, and may require any individual who is or appears to be so affected to furnish to such state or political subdivision thereof or any agency thereof having administrative responsibility for the law involved, the Social Security account number or numbers, if he has more than one such number issued to him by the Commissioner of Social Security. 42 USC Section 666. Requirement of statutorily prescribed procedures to improve effectiveness of child support enforcement. Types of procedures required in order to satisfy Section 654(20) of this title. Each state must have in effect laws requiring the use of the following procedures, consistent with this section, and with regulations of the Secretary, to increase the effectiveness of the program which the state administers under this part. 13. Recording of Social Security numbers in certain family matters. Procedures requiring that the Social Security number of any applicant for a professional license, driver's license, occupational license, recreational license, or marriage license be recorded on the application, b. Any individual who is subject to a divorce decree, support order, or paternity determination or acknowledgement be placed in the records relating to the matter, and c. Any individual who has died be placed in the records relating to the death and be recorded on the death certificate. For purposes of subparagraph A, if a state allows the use of a number other than the Social Security number to be used on the face of the document while the Social Security number is kept on file at the agency, the state shall so advise any applicants liable for violating the law and for violating your rights. Given this notice, the clerk may process your driver's license application. Get a letter of ineligibility from the Social Security Administration since passage of the various state laws attempting to require citizens to obtain Social Security numbers. Most states have learned that many people are not enumerated. This has caused a new problem for the states as they attempt to force everybody into the Social Security system, even against their will. In conjunction with the National Highway Traffic Safety Administration, the states have decided that they will issue a license if you can obtain a letter from the Social Security Administration stating that you are not eligible for a Social Security number. The Social Security Administration calls this letter SSAL 676 and explains it as follows. Of course, this latest move is simply a blatant attempt to force everybody into the federal Social Security system. But if you can obtain a form SSAL 676, then you can get your driver's license without a Social Security number. C. Getting your application rejected. On page 73 for how to do this. Sue the state for discrimination. There has recently begun a series of court cases where the plaintiff is seeking relief from providing a social security number when applying for a driver's license. These cases asserted the plaintiff belief that expanded use of the social security number too closely resembles the mark of the beast that is written about in the Bible. They claim that their religious conviction, protected under federal law, prevents them from providing a social security number. As such, the state should provide them relief from this requirement. If an individual applies for an SSN and the Social Security Administration SSA determines that he or she is not eligible for a number, SSA will, at the applicant's request, provide a letter of ineligibility for an SSN. The form letter, generally in SSAL 676, states the specific reason SSA cannot give the individual a Social Security card. The most common reason for an alien's ineligibility for an SSN is because he or she is not authorized to work in the United States. For such individuals, the letter states that we cannot give you a Social Security card because you are an alien not allowed to work in the United States. In some cases, the reason may also include that the alien has not provided evidence of a valid non-work reason. The document that provides evidence that an individual has not been assigned an SSN and is not eligible for one is Form SSAL 676. A person can obtain this form by applying for an SSN at any Social Security office and being found not eligible for an SSN. Upon request, the SSA office will give the individual a letter right away. SSA does not provide any document which states that an individual has not been issued an SSN, other than in connection with an application for an SSN. 1 Win Stephen Jones and Leo Guglielmo v. California DMV, Oct. 1998. 1 Loss Miller v. Reed, May 1999. Beware of the international driver's permit. There are many people fraudulently offering an international driving permit as a solution for those who cannot get a driver's license for various reasons. See Get an International Driver's License on page 204 for more information about this. The United Nations, in the Convention on International Road Traffic on September 19, 1949, established the International Driving Permit to facilitate the worldwide travel of motorists in foreign countries where language barriers create difficulties for both motorists and police. It has been ratified by more than 160 nations. For an international driving permit to be valid in any accepted country, it must be accompanied by a foreign driver's license. That is, you must also possess a valid driver's license from the country who issued the international driving permit. By itself, the permit is not valid. This means that if you expect to drive legally in the United States with an international driving permit, then you must also possess a valid driver's license from the country who issued you the international driving permit. International driving permits are intended for tourists. It is very important to realize that for an international driving permit to be valid in your state or country, you must have a driver's license issued from your state or country. State-issued licenses supersede an international driving permit in the state or country where they are being used. Voter registration. There are many registrar of voters offices requiring citizens to provide Social Security numbers when they register as voters. They get away with this illegal abuse because they are seldom challenged. However, the requirement has been defeated in every case when it is challenged in court. When you complete a voter's registration form, leave any space that asks for a Social Security number blank. Tell the registrar of voters that you have no Social Security number if they ask for it. Serve a copy of the notice regarding disclosure of Social Security number card, provided at the beginning of this section on the registrar of voters if they tell you that they cannot process your voter's registration form. This serves to notify the registrar of voters that he/she will be held personally and criminally liable for violating the law and for violating your rights. Given this notice, the registrar of voters will usually process the voter's registration form. Sue the bureaucrats. Also, when Nevada's Clark County Registrar of Voters Catherine Ferguson refused to let 18-year-old Joshua Hanson register to vote because he said he didn't have a Social Security number, Joshua sued. Clark County District Court Judge Gene Porter ruled against the County Registrar of Voters requirement on Oct. 26, 1998, and Joshua voted in the election. Schools often ask for a child's Social Security number as a matter of policy or habit. There is no law requiring a student to have a Social Security number to participate in public or private school. In fact, the law prohibits such a requirement. Section 7 of Public Law 93-579, as enacted by the Congress of the United States reads that when you complete an enrollment application for your child, leave any space that asks for a Social Security number blank. If they ask for a Social Security number, tell the school that neither you nor your child has one. Serve a copy of the notice regarding disclosure of Social Security number card, provided at the beginning of this section, on the person receiving the application if they tell you that they cannot process your application. This serves to notify them that they will be held personally and criminally liable for violating the law and for violating your rights. Given this notice, they will usually process the enrollment. Gradinger v. Davis, 988 F.2D1 3 44 U.S. Court of Appeals, 4th Circuit. As a consequence of registering to vote in the Commonwealth of Virginia, a registered voter's Social Security number SSN is subject to public inspection in the Office of the General Registrar and provided upon request to, among other entities, political parties as part of voter registration lists. Applying strict scrutiny, the District Court held that these provisions of Virginia's voter registration scheme do not violate appellants' fundamental right to vote. Gradinger v. Davis, 782 F. Sup. 1106 ed. Thaw. 1992. We now reverse. In summary, we hold that the public disclosure of Gradinger's SSN as a condition of his right to vote, it creates an intolerable burden on that right as protected by the First and 14th Amendments. Accordingly, the judgment of the District Court is reversed. We remand the case to the District Court to give the Commonwealth of Virginia the responsibility to cure this constitutional infirmity by either deleting the requirement that a registrant disclose his SSN or eliminating the use of SSNs in voter registration records open to public inspection and contained in voter registration lists provided to candidates for election, political party committees and officials, incumbent office holders, and non-profit organizations which promote voter participation and registration. 1. It shall be unlawful for any federal, state, or local government agency to deny to any individual any right, benefit, or privilege provided by law because of such individual's refusal to disclose his Social Security account number. School free lunch programs. School free lunch programs are subsidized by the United States Department of Agriculture. As an expectation of receiving federal money, the schools are asked to obtain a Social Security number from each participant. If the child does not have a Social Security number, the school will give the parents a Form SSA-5, application for Social Security card, and tell them that they must provide a Social Security number for participation in the program. They base their assertion on 42 U.S.C. Section 1758. However, the regulations implementing these lunch programs assert a different requirement. There is no requirement that the parents have or obtain a Social Security number. Nowhere in the regulation is there a requirement for the child to obtain a Social Security number. Additionally, the regulations provide for an indication that such member does not have one if parent does not a Social Security number. 42 U.S.C. Section 1758 School Lunch Programs. Program requirements. 1. The Secretary shall require, as a condition of eligibility for receipt of free or reduced price lunches, that the member of the household who executes the application furnish the Social Security account number of the parent. 7 CFR Section 1.123 Specific exemptions. Sec. 6 Social Security account numbers. No agency shall deny or permit any state or local government with whom it is involved in a cooperative venture to deny to any individual any right, benefit, or privilege provided by law because of such individual's refusal to disclose his or her Social Security account number. B. Paragraph of this section shall not apply with respect to 1. Any disclosure required by federal statute, or 2. Any disclosure to any agency relating to a system of records it maintained prior to January 1, 1975, if such disclosure was required under statute or regulation adopted prior to that date, to verify the identity of an individual. See any agency in the department which requests an individual to disclose his or her Social Security account number shall inform that individual whether the disclosure is mandatory or voluntary, by what statutory or other authority the number is solicited, and what uses will be made of it. The agency shall also ensure that this information is provided by a state or local government with whom it is involved in a cooperative agreement. 7 CFR Section 226.23 Free and reduced price meals. See the Social Security number of the adult household member who signs the application, or an indication that he/she does not possess a social security number. 7 CFR Section 245.6a Verification Requirements. Eligibility for free or reduced price meals. These households shall be advised of the type or types of information and/or documents acceptable to the school. This information must include a social security number for each adult household member or an indication that such member does not have one. Hunting and fishing license. Many states have implemented requirement that applicants for hunting or fishing license/permits provide a social security number as a result of Federal Law 42 U.S.C. Section 666. The law was implemented by Public Law 1-485, become effective on Oct. 1, 1985, and was modified in 1997 by Public Law 1-83 to include all driver's license and recreational license. However, Public Law 93-79 has not been changed and supersede the above requirement. Section 7 of Public Law 93-579, as enacted by the Congress of the United States, states that, according to a 2B of this law, a requirement for the disclosure of a social security number to any federal, state, or local agency is only lawful if such requirement was in existence and operating before January 1, 1975. Thereby, Congress prohibits any federal 42 USC Section 666 requirement of statutorily prescribed procedures to improve effectiveness of child support enforcement at types of procedures required in order to satisfy Section 654(20) of this title. Each state must have in effect laws requiring the use of the following procedures consistent with this section and with regulations of the Secretary to increase the effectiveness of the program which the state administers under this part. 13. Recording of Social Security numbers in certain family matters. Procedures requiring that the Social Security number of any applicant for professional license, driver's license, occupational license, recreational license, or marriage license be recorded on the application, b. Any individual who is subject to a divorce decree, support order, or paternity determination or acknowledgement be placed in the records relating to the matter, and c. Any individual who has died be placed in the records relating to the death and be recorded on a death certificate. For purposes of subparagraph A, if a state allows the use of a number other than the Social Security number to be used on the face of the document, while the Social Security number is kept on file at the agency, the state shall so advise any applicants. 1. It shall be unlawful for any federal, state, or local government agency to deny to any individual any right, benefit, or privilege provided by law because of such individual's refusal to disclose his Social Security account number. 2. That the provisions of paragraph 1 of this subsection shall not apply with respect to any disclosure which is required by federal statute, or b. The disclosure of a Social Security number to any federal, state, or a local agency maintaining a system of records in existence and operating before January 1, 1975, if such disclosure was required under statute or regulation adopted prior to such date to verify the identity of an individual. b. Any federal, state, or local government agency which requests an individual to disclose his Social Security account number shall inform that individual whether that disclosure is mandatory or voluntary, by what statutory or other authority such number is solicited, and what uses will be made of it. State or local agency from enforcing laws or regulations adopted after January 1, 1975 that require a Social Security number from people. When you complete an application for a hunting or fishing license, leave any space that asks for a Social Security number blank. Tell the clerk that you have no Social Security number if they ask for it. Serve a copy of the notice regarding disclosure of Social Security number card, provided at the beginning of this section, on the clerk if they tell you that they cannot process your application. This serves to notify them that they will be held personally and criminally liable for violating the law and for violating your rights. Given this notice, the clerk will usually process the form. Verify the applicable law. It is important to read the applicable laws because these laws often specify something very different from what you are being told. For example, in California, most Department of Motor Vehicle clerks believe that the law requires an applicant for a California driver's license or identification card to provide their Social Security account number, because the law reads. Notice that this code is not requiring an applicant to provide a number. The code simply states that the application form shall contain fields for the following information: It is very similar to CVC Section 1653.5. When we read the actual requirement to include a social security number, we discover that it is qualified with a strange phrase, notwithstanding any other provision of law. Notwithstanding any other provision of law is a strange phrase to find in the law because of what it means, that is, despite any law to the contrary. Despite any law that says we can't. Regardless of what other laws might say. You must obey the law, but we don't have to. The reason this phase is added to the law is because California's attempt to require a social security number does violate other provisions of law, such as provided for in Section 7 of the applicant's true full name, age, sex, mailing address, residence address, and social security number. California Vehicle Code CVC Section 12800 at every form prescribed by the Department for use by an applicant for the issuance or renewal by the Department of a driver's license or identification card pursuant to Division 6 commencing with Section 12500 shall contain a section for the applicant's social security account number. Notwithstanding any other provision of law, the Department shall require every application for a driver's license to contain the applicant's social security number and any other number or identifier determined to be appropriate by the Department. CVC Section 12800.1. Public Law 93-579, which contain a shall not apply provision at B for a system of records in existence and operating before January 1, 1975. All of these new state requirements for a social security number have been adopted after 1975 and therefore were not in existence and operating before January 1, 1975. Also, upon closer reading of CVC Section 1653.5, this law is necessary because Public Law 93-579 prohibits California from requiring an applicant's social security number. So they additionally attempt to prohibit their employees from processing applications that do not include the applicant's social security account number. Of course, it's still against the law to deny any individual any right, benefit, or privilege because of such individual's refusal to disclose his social security number. California, like most other states, also attempts to require applicants for various professional licenses to provide social security numbers in violation of Public Law 93-579. And in each case they acknowledge the existence of contrary law. And it's critical to review each applicable law carefully when you are dealing with various state agencies. Most states have drafted laws with similar wording. Read the law carefully because it probably not require you to do anything, but instead is doing one of the following. Attempting to restrict the duty of a state employee. Defining the appearance or data field to include on a form. Despite any other provision of law, trying to trick you into believing you are required to provide something that they cannot require you to do. D. The Department shall not complete any application that does not include the applicant's social security account number or driver's license or identification card number as required by Subdivision C. Notwithstanding any other provision of law, any board, as defined in Section 22, and the State Bar and the Department of Real Estate shall at the time of issuance or renewal of the license require that any licensee provide its federal employer identification number if the licensee is a partnership or his or her social security number for all others. California Business and Professions Code Section 30. Notwithstanding any other provision of law, the Commissioner shall at the time of issuance or renewal of any license under this chapter or Chapter 6 commencing with Section 1760, Chapter 7 commencing with Section 1800, or Chapter 8 commencing with Section 1831. Require that any licensee provide its federal employer identification number if the licensee is a partnership or his or her social security number for all others. California Insurance Code Section 1666.5. 89. Dealing with the public. Usually it is quite easy to deal with the general public regarding issues of privacy and withholding a social security number. Often the people who ask you for a number are impressed to learn that the people do have rights and that there are laws that actually prohibit people from requiring disclosure. When dealing with the public, most people who ask you for a social security number are simply doing it out of the misguided belief that some mysterious law requires everybody to be branded slaves of the system. While these people are sometimes offended by your simple refusal, particularly if they are foreigners, Most become quickly impressed when you explain the legal reasons that protect you from disclosing a social security number. Most people are disgusted with the idea that they have lost a good part of their freedom. These people often become excited to learn that many of the chains they have been wearing have been held in place by their own ignorance of the law. You will quickly discover that many people are really excited to learn how easy it is to regain so much of their lost freedom and privacy. Now that you are a serious student of this topic, you have an obligation to share your knowledge and insight. One excellent way of doing this is simply to become more outspoken about these important issues. Of course, in all cases where the offending party persists in the request, you can assert your legal rights and remind them that they are violating the law. However, you should always practice the degree of diplomacy that is warranted by each situation. For example, being perceived as a tough guy looking to sue people while trying to rent an apartment is not usually the wisest approach. One excellent way of doing this is simply to become more outspoken about these important issues. Renting. Most rental applications ask a prospective tenant for a social security number while requesting your permission to obtain a credit report and to check for previous evictions. Many rental agencies and rental owners also ask you to pay the processing fee for this credit check. Here are several reasonable alternatives to this request. Simply ask the prospective landlord if a social security number is really necessary. Tell them that you consider this very private information and would prefer not sharing it with anyone other than government agencies who absolutely require it. After a reasonable explanation, most people will admit that they really don't need it. Obtain a copy of a credit report before you begin looking for a rental. Carry the original with you so that prospective landlords can know that it is authentic and leave them an extra copy. Not only does this save you money, but it makes their job easier because they don't need to run the credit check. Obtain letters of recommendation from previous landlords or rental agencies. These letters are actually the best alternative because they tell your prospective landlord exactly what they need to know: that you are an excellent tenant. Utility suppliers usually ask for a social security number because they want to check your credit worthiness or because they like to use the number as a unique identifier. Most utility suppliers don't press the issue when you decline to provide a social security number. For those that do, you should explain that you don't have a social security and that the Privacy Act Public Law 93-579 makes it unlawful for any person to require an individual to disclose or furnish a social security number for any purpose, unless the disclosure or furnishing the number was specifically required under federal law. Then ask them to please tell you which law requires disclosure of a social security number in this instance. If they persist, explain that since passage of the Privacy Act in 1974, the federal courts have ruled that it applies equally to the private sector. Their requests for social security numbers must conform to the disclosure requirements of the Privacy Act. See Yeager v. Hackensack Water Co. 615 F. Sup. 1087 DCNJ. 1985. The utility company cannot use lack of a social security number in any adverse way against anyone, unless they can show that it is required by law. Insurance companies use the social security number as a unique identifier. Again, very few companies will persist when you decline to provide it. If they do, then follow the advice given above. Medical doctors, hospitals, and dentists often ask new patients for a social security number because they use the number as a unique identifier for their records, computer entry, and to bill the insurance company. They routinely ask you for this information on their forms for new patients. Usually you can quell this request by simply leaving the SSN field blank. Most professional service providers will not ask you for this information directly and simply ignore it or create some kind of substitute number for their computer. Dealing with the public 91. Don't number your baby. Most hospitals and county officials will tell you that you must complete the forms necessary to obtain a social security number for your baby before your baby can leave the hospital. Of course, no such requirement exists. According to the Social Security Administration, getting a social security number for your baby is strictly voluntary. Here is an excerpt from SSA publication there 5 You should obtain a copy of this publication before your baby is born, so that you can show it to hospital officials. Occasionally, a hospital will send a goon to tell you that the law, specifically 42 U.S.C. 405 C2C, requires them to obtain a social security number or a birth certificate cannot be issued. This is simply a bogus argument. The best way to deal with that threat is to simply tell them fine, then don't issue a birth certificate. If the baby was born, then the hospital has no choice but to draft a record of live birth and send it the local county recorder's office. It is the policy of the United States that any state or political subdivision thereof may, in the administration of any tax, general public assistance, driver's license, or motor vehicle registration law within its jurisdiction, utilize the Social Security account numbers issued by the Commissioner of Social Security for the purpose of establishing the identification of individuals affected by such law, and may require any individual who is or appears to be so affected to furnish to such state or political subdivision thereof or any agency thereof having administrative responsibility for the law involved, the Social Security account number or numbers, if he has more than one such number issued to him by the Commissioner of Social Security. Roman II. In the administration of any law involving the issuance of a birth certificate, each state shall require each parent to furnish to such state or political subdivision thereof or any agency thereof having administrative responsibility for the law involved, the Social Security account number or numbers, if the parent has more than one such number issued to the parent unless the state in accordance with regulations prescribed by the Commissioner of Social Security finds good cause for not requiring the furnishing of such number. The state shall make numbers furnished under this subclause available to the Commissioner of Social Security and the agency administering the state's plan under Part D of Subchapter Roman IV of this chapter in accordance with federal or state law and regulation. Such numbers shall not be recorded on the birth certificate. A state shall not use any Social Security account number obtained with respect to the issuance by the state of a birth certificate for any purpose other than for the enforcement of child support orders in effect in the state, unless Section 7 of the Privacy Act of 1974 does not prohibit the state from requiring the disclosure of such number, by reason of the state having adopted, before January 1, 1975, a statute or regulation requiring such disclosure. County creates a birth certificate based on these records. You can request a birth certificate anytime you wish. There have been a few rare instances when a hospital goon threatens to refuse to let you leave the hospital with your baby if you don't first apply for a Social Security number. They usually don't realize that they are threatening to kidnap a child, and such a threat is a serious crime. For the sake of getting good evidence, ask them to put that threat in writing. You should take such a threat seriously and immediately speak to upper management. Be sure to explain that you are clearly offended by such threats and will turn it over to the appropriate authorities if necessary, and you may even seek civil damages. Credit reporting agencies use the Social Security number as a unique identifier. They obtained the Social Security number from you when you completed a credit application. They believe that their authority to use the Social Security number came to them by way of your signing the credit application. Credit reporting agencies can only use information that they obtain from one of the following sources: directly from information that you give them on a credit application, directly from a company that you ask for credit, directly from a company that provides you credit. Public records. How the major credit reporting agencies identify you. Every credit reporting agency has a particular system of file retrieval that allows them to identify the file of each person in their system. It is necessary to identify each file in such a manner as to separate individuals with similar names and addresses so that Robert Jones will not appear on the file as Bob Jones. However, no bureau has yet come up with a perfect system of file identification. That is why you will sometimes see items on a credit report that belong to someone else with a similar name. In an effort to maintain maximum efficiency, credit reporting agencies prefer to set up more than one file per person rather than risk merging several people's files into one. This is the weak link in the system. Credit reporting agencies have two basic types of file identification. One type is used by Experian, Equifax, and other major credit reporting agencies, with the exception of TransUnion. TransUnion uses the other type. The first type uses the following sequence of information to match an existing file. If the information does not match, a new file is created. The other system is based entirely on an applicant's Social Security number, Employer Identification Number (EIN), and Taxpayer Identification Number (TIN). If it does not match the name, a new file will be created. How to establish a new credit file? Unlike employers, credit reporting agencies do not check the validity of a Social Security number or anything else given to them, for that matter. They simply attempt to match data records, create new data records, and maintain files. Understanding this is the key to creating field comments. Last name: the computer only recognizes the first 10 digits of the last name. Letters must match an existing file, or a new file will be created and the computer will stop the search. Otherwise, the computer will proceed. First name: if the last name matches an existing file, the computer will continue by matching the first 3 letters of the first name. If the first name matches an existing file with the same first name and last name, it will then proceed to match other segments. Otherwise, a new file will be created. Middle initial: once the last name and first name have been matched, the computer will proceed to match the middle initial. If all segments match, the program will continue. Otherwise, it will either create a new file or skip the middle initial and proceed with the checking. Spouse: if married, the spouse's first initial will appear after the file holder's middle initial. If not married, the computer will proceed to match other segments. House number: after matching all the above segments, the computer will proceed to match the first 5 digits of the house number and continue. Street name: the computer will proceed by matching the first letter of the street. Zip code: the computer will proceed to match address with zip code. If 5 years or more at present address, the computer will stop. A search revealing persons with similar names and addresses will result in the files being merged and a flag will be added to the file. Previous address: if less than 5 years at present address, the computer will check previous addresses. The computer can hold up to 10 previous addresses, but will usually list only the last 3. Date of birth: the computer will proceed to match the year of birth only. You do not have to use your complete date of birth. Only enter year of birth on any applications you make. Social Security number: the computer will proceed to match all of the previous elements with the Social Security number. If the Social Security number does not match the previously reported number, a flag will be added to the file. The Credit Reporting Agency also maintains files on employer ID numbers (EIN) and taxpayer ID numbers (TIN). A new credit report. Creating a new credit report is as simple as completing a mail-in credit application for a credit card. You can enter anything on the application you wish, but it is prudent to be realistic. Your credit application will very likely be rejected for something like no credit file exists or insufficient credit history. Of course, if it is a new identity, it is not surprising that a credit file does not exist. However, at the moment they got that reply, the agency's computer also created a new file, and now it does exist. Next, apply for a credit card or just wait for the pre-approved junk mail to arrive. Now that you have a credit history, it will come. Complete an application for secured credit card. You are pre-approved if the information you put on the application matches the information in your credit file and you pay the deposit they want. If you use the card and always pay your bill properly, you will quickly begin establishing a quality credit history. Also note that the credit report does not reflect the fact that you have secured credit card, so others will only know that your credit history is good. Never merge your new credit with your old credit file. Here are some simple items to avoid when establishing your new file. Avoid asking for credit at places where you previously had credit. Do not open an account at a bank where you've done business in the past. Do not give out previously used credit references. Do not use addresses, phone numbers, relatives, etc. that you used in your previous file. Avoid having your spouse listed on your credit applications. No joint credit. Avoid using Social Security number. Do not use checks from your old accounts to pay new creditors. If you use a Social Security number, do not give it to anyone you had contact with in the past who could connect you with your past credit file. When starting this new process, you may be asked, why don't you have any credit? This is easily countered by saying you've been out of the country for several years, or that you were in the military, self-employed, or had no previous desire for credit. The Fair Credit Reporting Act amendments to the Fair Credit Reporting Act (FCRA), effective September 30, 1997, benefit consumers by strengthening privacy provisions and defining more clearly the responsibilities and liabilities of businesses that provide information to and access data from credit reporting agencies. Information in your credit report can affect your ability to get a job, a mortgage, a loan, a credit card, or insurance. Get a copy of the credit report. To obtain a copy of your credit report, contact Equifax 800-685 211 Xperia, formerly TRW 888 Xperia 397 742. TransUnion 800-916-8800. You can contact the credit reporting agencies to remove your name and address from the lists used for unsolicited credit and insurance offers for 2 years. If you complete and return an opt-out form provided on request from the credit reporting agency, you will be off these lists permanently. A phone call or mailing to any one of the 3 nationwide credit reporting agency will get you off the lists. To opt out of credit card and insurance lists, 1-800-88 HIPSUAT 1-800-88 837 for all 3 credit reporting agencies. Regardless of what the credit reporting agency tells you, a social security number is not needed to obtain a copy of a credit report. The law, 15 U.S.C. Section 1681H, provides only that you furnish proper identification. Simply providing them with the minimal information needed to uniquely identify you is all that is required. Reporting violations of the law, you can file a complaint with the Federal Trade Commission by contacting the Consumer Response Center by phone. Toll-free 1-877-FTC Help 382-4357 TDD 202-326-2502 by mail. Consumer Response Center, Federal Trade Commission, 600 Pennsylvania Ave, NW, Washington, D.C. 20580, or through the Internet using the online complaint form. Although the Commission cannot resolve individual problems for consumers, it can act against a company if it sees a pattern of possible law violations. The Federal Trade Commission publishes free brochures on many consumer issues. For a complete list of publications, write for Bestsellers, Consumer Response Center, Federal Trade Commission, 600 Pennsylvania Ave, NW, Washington, D.C. 20580, or call toll-free 1-877 FTC Help 382-4357 TDD 202-326-2502. A summary of your rights under the Fair Credit Reporting Act. The Federal Fair Credit Reporting Act is designed to promote accuracy, fairness, and privacy of information in the files of every consumer reporting agency. Most consumer reporting agencies are credit reporting agencies that gather and sell information about you, such as if you pay your bills on time or have filed bankruptcy. They sell this information to creditors, employers, landlords, and other businesses. 15 U.S.C. Section 1681H Conditions and Form of Disclosure to Consumers. In general, 1 Proper identification a consumer reporting agency shall require, as a condition of making the disclosures required under Section 1681G of this title, that the consumer furnish proper identification. 2 Disclosure in writing except as provided in subsection B of this section. The disclosure required to be made under Section 1681G of this title shall be provided under that section in writing. The Fair Credit Reporting Act, codified at 15 U.S.C. Section 1681, 1681U. The Fair Credit Reporting Act gives you specific rights as outlined below. You may have additional rights under state law. You may contact a state or local consumer protection agency or a state attorney general to learn those rights. You must be told if information in your file has been used against you. Anyone who uses information from a consumer reporting agency to take action against you, such as denying an application for credit, insurance, or employment, must tell you and give you the name, address, and phone number of the consumer reporting agency that provided the consumer report. You can find out what is in your file. At your request, a consumer reporting agency must give you the information in your file and a list of everyone who has requested it recently. There is no charge for the report if a person has taken action against you because of information supplied by the consumer reporting agency if you request the report within 60 days of receiving notice of the action. You also are entitled to 1 free report every 12 months upon request if you certify that 1 you are unemployed and plan to seek employment within 60 days, 2 you are on welfare, or 3 your report is inaccurate due to fraud. Otherwise, a consumer reporting agency may charge you up to $8. You can dispute inaccurate information with the consumer reporting agency. If you tell a consumer reporting agency that your file contains inaccurate information, they must investigate the items usually within 30 days by presenting to its information source all relevant evidence you submit, unless your dispute is frivolous. The source must review your evidence and report its findings to the consumer reporting agency. The source also must advise national consumer reporting agencies, to which it has provided the data, of any error. The Consumer Reporting Agency must give you a written report of the investigation and a copy of your report if the investigation results in any change. If the Consumer Reporting Agency's investigation does not resolve the dispute, you may add a brief statement to your file. The Consumer Reporting Agency must normally include a summary of your statement in future reports. If an item is deleted or a dispute statement is filed, you may ask that anyone who has recently received your report be notified of the change. Inaccurate information must be corrected or deleted. A consumer reporting agency must remove or correct inaccurate or unverified information from its files, usually within 30 days after you dispute it. However, the consumer reporting agency is not required to remove accurate data from your file unless it is outdated as described below or cannot be verified. If your dispute results in any change to your report, the Consumer Reporting Agency cannot reinsert a disputed item back into your file unless the information source verifies its accuracy and completeness. In addition, the Consumer Reporting Agency must give you a written notice telling you it has reinserted the item. The notice must include the name, address, and phone number of the information source. You can dispute inaccurate items with the source of the information. If you tell anyone, such as a creditor who reports to a Consumer Reporting Agency, that you dispute an item, they may not then report the information to a consumer reporting agency without including a notice of your dispute. In addition, once you've notified the source of the error in writing, it may not continue to report the information if it is, in fact, an error. Outdated information may not be reported. In most cases, a consumer reporting agency may not report negative information that is more than 7 years old, 10 years for bankruptcies. Access to your file is limited. A consumer reporting agency may provide information about you only to people with a need recognized by the Fair Credit Reporting Act, usually to consider an application with a creditor, insurer, employer, landlord, or other business. Your consent is required for reports that are provided to employers, or reports that contain medical information. A consumer reporting agency may not give out information about you to your employer or prospective employer without your written consent. A consumer reporting agency may not report medical information about you to creditors, insurers, or employers without your permission. You may choose to exclude your name from consumer reporting agency lists for unsolicited credit and insurance offers. Creditors and insurers may use file information as the basis for sending you unsolicited offers of credit or insurance. Such offers must include a toll-free phone number for you to call if you want your name and address removed from future lists. If you call, you must be kept off the lists for 2 years. If you request, complete, and return the Consumer Reporting Agency form provided for this purpose, you must be taken off the list indefinitely. You may seek damages from violators. If a consumer reporting agency, a user or in some cases a provider of consumer reporting agency data, violates the Fair Credit Reporting Act, you may sue them in state or federal court. Dealing with idiots, there are always those idiots who, no matter what you say, they simply refuse to believe you. These people will not take the time to study the issues or laws, and continue as the pompous asses that they truly are to demand that you provide them with a social security number. The following form is especially useful for advising these kinds of people in a very serious way, that they may be headed for much more trouble than they had anticipated. This form provides space for you to record the incident, gives them fair legal notice, and provides them an opportunity to cease with their demand and comply with the law. Completing this form and making a copy serves as a witness that they were informed of the law and their legal obligations. It is a very effective tool when you seek a criminal indictment against them or when you sue them. This form is a real barn burner when you are getting ready to kick butt. Knowing the criminal, many times the unenumerated are unknowingly victims of a crime. The most notable example of this is when someone tells you that you must have, or you must provide a social security number because it is the law. Most often that statement that it is the law is a criminal violation of the law, which, if proven, could subject the person who said it to fines and jail. Form SSN Citizens Assertion of Legal Right to Withhold Disclosure of SSN Public Law 93-579 Section 7. Name and address of citizen. Name and address of notice recipient. Citizen statement. I certify that the foregoing information stated here is true and correct. Citizen's signature date legal notice and warning. Federal law provides that it is a crime to violate the rights of a citizen under the color of law. You can be arrested for this crime and can also be held personally liable for civil damages. Federal law, Section 7 of Public Law 93-579 provides that it shall be unlawful for any federal, state, or local government agency to deny to any individual any right, benefit, or privilege provided by law because of such individual's refusal to disclose his Social Security account number. Federal courts have ruled the Privacy Act applies equally to the private sector. Warning: you are in violation of federal law, and persisting with your demand may lead to your arrest and or civil damages. The law provides that you can be held personally responsible and liable, as well as your company or agency. There is no law requiring an individual to obtain or use a Social Security number. Your requirement and or demand that I provide a Social Security number to you is a violation of one or more of the following laws: 4 CFR 83.9, 5 USC 552A, 7 CFR 1.123, 7 USC 2204G, 14 CFR 1212.604, 17 CFR 249.501A, 19 CFR 118.11, 19 CFR 122.25, 19 CFR 24.5, 24 CFR 5.212, 28 CFR 16.53, 28 CFR 513.31, 28 CFR 700.25, 29 CFR 78.10, 29 CFR 71.12, 31 CFR 1.32, 31 CFR 501.806, 32 CFR 270.19, 32 CFR 310.20, 32 CFR 311.5, 32 CFR 316.6, 32 CFR 317.20, 32 CFR 323.5, 32 CFR 505.2, 32 CFR 701.108, 32 CFR 806B.9, 38 CFR 1.575, 38 CFR 3.216, 38 USC 5101, 39 CFR 266.4, 45 CFR Part 801, 47 CFR 0.554, 49 CFR 10.29. You are advised to cease and desist with your demand and to seek personal legal counsel if you do not understand the law. Notice of service. I certify that I personally delivered this notice to above-named recipient and address on it. 42 USC 408 provides that whoever 8 discloses, uses, or compels the disclosure of the Social Security number of any person in violation of the laws of the United States shall be guilty of a felony and upon conviction thereof shall be fined under Title 18 or imprisoned for not more than 5 years, or both. 18 U.S.C. Section 242 and 42 U.S.C. Section 1983 provides that whoever, under color of any law, statute, ordinance, regulation, or custom, willfully subjects any person in any state, territory, or district to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States, shall be fined under this title or imprisoned not more than 1 year, or both. 42 U.S.C. Section 1983 further provides that a violator shall be liable to the party injured in an action at law, suit in equity, or other proper proceeding for redress. Public Domain Privacy Form SSN 02-2000. For example, 18 U.S.C. Section 242 and 42 U.S.C. Section 1983 provides that, and 42 U.S.C. Section 408 provides that. It is also good to be familiar with these. If these crimes are committed against you, and you can prove it, you should talk to your local district attorney about filing a criminal complaint. If your evidence has legal merit, the local district attorney is obligated to pursue the case. Whoever, under color of any law, statute, ordinance, regulation, or custom, willfully subjects any person in any state, territory, or district to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States, shall be fined under this title or imprisoned not more than 1 year, or both. 42 U.S.C. Section 1983 further provides that a violator shall be liable to the party injured in an action at law, suit in equity, or other proper proceeding for redress. However, 8 discloses, uses, or compels the disclosure of the Social Security number of any person in violation of the laws of the United States, shall be guilty of a felony and upon conviction thereof shall be fined under Title 18 or imprisoned for not more than 5 years, or both. 18 U.S.C. Section 2425 Use of interstate facilities to transmit information about a minor. Knowingly initiates the transmission of the name, address, telephone number, Social Security number, or electronic mail address. 42 USC 1307 Penalty for fraud. Whoever, with the intent to elicit information as to the Social Security account number, shall be deemed guilty of a felony. 7 CFR 400.410 Penalties. Unauthorized disclosure of SSNs or EANs by any person may subject that person, and the person soliciting the unauthorized disclosure, to civil or criminal sanctions imposed under various federal statutes, including 26 U.S.C. 7613, 5 U.S.C. 552A, and 42 U.S.C. 408. This audiobook was created by the Mental Chemist for Personal Study and Education, copyright 2025.